Sorry, it's loading. Why does it never show that it's live? Oh, cool.
Good morning, everyone. Our first case for argument this morning is United States versus David Godwin. Ms. Riley.
May it please the court. Simply put, the district court in this case erred by applying the two-level obstruction enhancement, and that error was not harmless. The court applied the enhancement based on a perjury finding as to a statement that my client made while representing himself at sentencing. When the obstruction enhancement is applied because of a perjury finding, that perjury must be material. Here, the sole basis for the court's finding of perjury was that it did not believe that Mr. Godwin did not recall directing a co-defendant to impersonate another individual, which was one act in a larger, years-long fraud scheme. That alleged perjury was not material, as it had no realistic possibility of lowering Mr. Godwin's sentence. And the government has not shown otherwise, particularly where Mr. Godwin's admissions made via his plea and other statements at the sentencing hearing were more than a sufficient factual basis to support the sentence that he received. In order to qualify for the obstruction enhancement, his statement needed to go to an issue before the district court. However, the only issue before the district court was the proper sentence. And that sentence was based on the sentencing guidelines, and there was no evidence in the record showing how Mr. Godwin's alleged failure to recall that particular event could have impacted the sentencing guidelines.
Does your client acknowledge to this day that it was an intentionally false statement? As we stand here now?
We are here today only challenging the materiality of the statement.
So in other words, he acknowledges that he lied under oath?
We are not making an acknowledgement that he lied. We are simply saying that that was not challenged, or that was not an issue in the record that my client challenged at the lower court.
Yeah, I think the way I read the transcript, what so troubled the district court is that the false statement went to the heart of the offense conduct. It seemed like it was a very substantial part of what the defendant was doing to deceive, who was it, AT&T? And the district court judge thought it's not remotely believable that you don't recall that. And that it does seem material to an application of the 3553A factors, or at least relevant to an application of those factors.
Yes, so to address that question, I believe that the record indicates actually that the particular statement at issue was tied to the events on one date in a broader fraud scheme, and that impersonations were part of that broader fraud scheme on numerous occasions. Throughout the record, my client admits on several different pages, different impersonations and forgeries that constituted part of that fraud scheme. So as to his recall about the events of a particular day, it's our contention that his recall of that event is not in and of itself material. Further,
Ms. Riley, though, getting back to Judge Scudder's point, let's assume, for the purpose of argument, as I think the parties are asking us to do, that Mr. Godwin did intentionally state a misrepresentation to the court, and the court found, or at least the court found that he did, and that's not being challenged. If that's the case, 3553A, one of the factors is history and characteristics of the defendant, right? And if the district court believes that Mr. Godwin is capable of lying under oath and committing perjury, which is another crime, wouldn't that be relevant to that particular factor in sentencing?
Your Honor, it would not be sufficient for the obstruction enhancement in this case, because the case law is quite clear that not every lie warrants the obstruction enhancement. If that was the case, then there would be no limiting principle, and every lie could be used to apply the enhancement.
But the judge in this case was trying to understand exactly what were the events that transpired as part of this crime, right? And as part of that analysis, he relied upon the statements of Mr. Godwin. And if those statements were basically misrepresented what had happened, why wouldn't that obstruct the district court's ability to determine what the actual circumstances of the offense were?
I think that the record shows my client admitted enough facts that that more than substantiate the underlying conduct. And again, the district court did not say that he did not believe that that event did not occur. He said he did not believe that my client did not recall that event. If he had believed that my client had not recalled that event, there is nothing in the record indicating how that would have specifically impacted the sentencing determination. Whether or not
doesn't it go to his credibility? I mean, he's on. I think I'm reading it the way Judge Lee is, in that he's on the stand, asked about the whole purpose of the hearing. Was it not? Was the loss amount? He challenged the loss that AT&T sustained. Correct?
Yes.
And in the course of testifying to that issue, he makes a statement that the district court finds to be intentionally false. Doesn't that obstruct the proceeding that's occurring, fact finding, when and go very much to his credibility?
As to his credibility, the courts have been clear that simply downplaying one's culpability is not sufficient to rise to the level of an obstruction enhancement.
Right, but we have more than that here. You have a finding of perjury.
Exactly, Your Honor. And credibility is a separate determination under the 3553 factors, which the court did take into account at that time. And as you noted, loss was the only issue on the table. And as our briefing demonstrates, even if believed that my client did not recall the events of that day, there's no monetary number that ties to that. In fact, unlike the government's brief indicates, if you look at the PSR, it quite clearly lays out a pattern of conduct over a long period of time with numerous misrepresentations, impersonations, and things of that nature. So this one instance could not have been tied to a monetary event, and because loss was the issue under a determination, it would not have impacted that calculation.
Loss amount wasn't the only issue being litigated. The overall sentence was being litigated. This was not a stipulated sentence of any kind. The loss amount was the contested point regarding the guidelines inputs, but the overall sentence that the court imposes is always at issue or under determination, to use the language of the obstruction enhancement. The overall sentence is always under determination at a sentencing proceeding.
Yes, Your Honor.
And so a lie of this sort, which goes to relevant conduct and the scope of his deception and cover-up of the fraud, is certainly material to the overall sentence, which could be above guidelines or below guidelines.
Yes, Your Honor. I'm simply trying to make the point that the statement at issue was given in the context of a loss contested.
Right, but your argument in the briefs anyway, and it seems to be the same here, is taking too narrow a view of materiality. It's not, the point is not that the lie has to be material to the loss amount determination, but to something at issue or under determination in the court's fashioning of the overall sentence.
And
Yes, Your Honor.
You know that's the case because the district court said so, that he was inclined to impose a much lower sentence until Mr. Godwin perjured himself in the sentencing proceeding. I mean, it's right in the transcript.
Yes, Your Honor. He also mentions that his decision was based off what he considered my client's frivolous contestation of that loss amount. But again, we would say that because the materiality is tied to a specific issue under determination, that this case is different, for example, than the case of Mercado, where the Seventh Circuit found that even if believed, the statements would not have had a realistic possibility of affecting a sentencing enhancement. In that case, it was being a minor participant. In this case, there is not a similar calculation that can be tied to this. And I would just like to additionally make the point that this is not harmless error because despite the fact that my client received a below guideline sentence, as this court found recently in the United States versus Bravo, a below guideline sentence can still be not harmless error and require vacatur when when it's not clear that the district court would have given the same sentence either way, which I believe you just noted the district court made clear it would not have. So for all of those reasons, we would ask for vacature and an instruction to the district court to not apply the obstruction enhancement at resentencing.
Thank you. Ms. Donahue.
Good morning, and may it please the court. My name is Megan Donahue, and I represent the United States. This court should affirm defendant's sentence. The district court correctly applied the obstruction of justice enhancement under guideline 3C 1.1 after defendant committed perjury at sentencing. Defendant's perjury was material because it went to the heart of the offense at issue and had the ability to impact his sentence, which was the issue under determination. I'd like to start by addressing some of the questions posed to appellant's counsel. First, as appellant's counsel noted, the issue before the district court was the sentence. It was not solely the loss amount, as your honors noted. Although the sentencing hearing was originally supposed to be focused solely on the loss amount as to AT&T, defendant instead broadened it to become about much more, not only in the 3 supplemental sentencing memoranda that he filed, but then at the sentencing itself, when he took the stand, chose to testify, and started to contest several key actions that he took in perpetuating his fraud scheme. Because his testimony in both the supplemental sentencing memoranda and at the sentencing itself undercut the very role he played in the scheme and how he perpetuated it and directed others to perpetuate it, it was material. Further, as your honors pointed out, the false testimony that defendant participated in clearly had the ability to affect the sentence, not only with respect to the 3553A factors, as your honors pointed out, but also with respect to several of the sentencing enhancements that were applied. Obviously, the obstruction of justice enhancement, the acceptance of responsibility enhancement, the sophisticated means enhancement, and the leader organizer enhancement. If defendant had been believed that he did not direct these impersonations, it is possible that the district court would not have imposed several of those enhancements or reductions. Because the district court's application of the enhancement was appropriate, the sentence should be upheld. First, focusing again on the materiality. Defendant does not contest that his lies were willful or that he did in fact lie on the stand. He only contests whether the lies were material. Under application note 6 of the guideline, lies are material if, when believed, they would tend to influence or affect the issue under determination. Defendant here lied to try and get a lower sentence. He lied under oath about directing Coletti to impersonate Ross, an AT&T employee, on several occasions, as the record reflects on pages 57, 61, and 76. Even after being confronted with specific emails and texts that explicitly showed that defendant had asked Coletti to impersonate both Ross and Greenewalt, a Hutchison employee, defendant continued to lie, as the record indicates on pages 62 and 56. These lies went to the very heart of the fraud. Directing Coletti to impersonate Ross was an essential part of the scheme. It kept the scheme going by providing false assurances to Forest Capital with respect to the first factoring agreement and allowing defendant to enter into a second factoring agreement with Forest Capital and Vion. The lies and the impersonations bought defendant time and money and bore directly on his culpability for the scheme and the key role that he played in executing it. Second, defendant's perjury could easily have affected his sentence, which was the issue under determination. The district court stressed that the impersonations or the perjury about them did in fact factor into its sentencing analysis. As the district court noted, These brazen impersonations were an extraordinarily serious aspect of the fraud. Defendant directed them, and these impersonations constituted too important an episode for defendant not to remember it. As Your Honors pointed out, the district court went on to note that he would have imposed a radically different sentence had defendant not chosen to perjure himself on the stand. The lies would also have influenced the court's 5553 analysis. Because defendant lied about a critical part of the scheme, and those lies had a reasonable probability of affecting the sentence, the lies were material and the enhancement was properly applied. I'd also like to note that the district court sufficiently explained why it imposed the enhancement. As the Seventh Circuit has noted, the district court is not required to make separate and distinct findings with respect to each of the three elements of perjury. As long as the district court makes factual findings to support its application and explains that reasoning, it has made a sufficient finding. Here, the district court's rationale and explanation of why defendant lied and why those lies were material was more than sufficient to impose the enhancement. First, the court found that defendant lied by clearly stating that he did not believe defendant, that he did not believe that the defendant didn't remember the impersonations, and that defendant made the fateful decision to lie in court. Second, it found that defendant's lie was willful. Third, it found the defendant's lie was material. Again, noting, as the record reflects on pages 76, 98, and 99, that these impersonations were too important, that the impersonations were brazen, and that this was an extraordinarily serious aspect of the frauds. The court therefore created a record of how defendant's perjury sought to downplay the seriousness of the offense and his role in it, and thus was capable of influencing the sentence. Finally, the district court did not need to link the materiality of defendant's perjury to the parties' dispute over the loss amount. First, the perjury did not need to impact the loss amount. The issue under determination here was the defendant's sentence, and clearly the perjury could have affected the sentence if those lies had been believed. Even assuming that the perjury did need to be connected to the loss amount, it was. Coletti's impersonations of Ross were not unrelated to the loss amount. The record highlights the importance of these impersonations and the key role they played in defrauding AT&T, Vion, and Forest Capital. This was a deliberate attempt to mislead the court. Defendant tried to diminish the severity of the offense and minimize his role. Unless there are any questions, the government respectfully requests that this court affirm defendant's sentence.
Thank you. Ms. Riley, your time had expired, but you may have a minute to offer some concluding thoughts before we call the next case.
Thank you, Your Honor. Briefly, I would like to note for the court that Mr. Godwin had admitted numerous actions that actually justified the loss amount in this case. On pages 60 through 62 of the record, 67, 68 through 69, the impersonations that opposing counsel mentioned as far as Mr. Greenwald and Hutchinson, those were all acknowledged by my client when he admitted actions that constituted the loss at issue here. So again, for the reasons we earlier discussed, we would ask for a remand of this sentence.
Thank you. Our thanks to both counsel. The case is taken under advisement, and we'll move to our second case this morning, McCorkle versus Kijakazi.
Good morning.
Mr. Forbes, good morning.
My name is Randall Forbes. I represent the disability claimant. This is a case that was decided at what we call Step 4, which I know all of you are familiar with. And a couple of points. This is a worker that has a very long, consistent work history before the alleged onset date. And that's important context. The second thing when we're dealing with migraines is that migraines are not objectively diagnosed by tests, whether it's MRIs or CT scans or the like. They are a clinical diagnosis based upon the doctor's examination of the patient and the identification of certain presentations of the headache. Here, the claimant tried typical migraine medications. Tried Maxalt, which is prophylactic or preventative, Imitrex, which I believe is a more long-term preventative, and then also tried propranolol, which generally slows blood pressure, which the thought is that it will then help the brain deal with the issues of constricting and dilation of blood vessels.
Mr. Forbes,
Yes.
Focusing on the evidence in the record, is there any evidence that her migraines worsened over time? And the reason I'm asking you that question is because the migraines seem to have started about 1998, about 10 years after that car accident.
Yeah,
And she worked, did she not,
right.
from 1998 until 2018.
Correct.
And so she worked while she was experiencing migraines. So did they worsen over time?
I don't know if there's anything in the record specifically that occurred, but the most important piece of evidence that did occur is that this person stopped working. She had this long history of work at a sedentary job, not a lot of exertion required. I would suggest that her job.
Does the record show that didn't she faint or have a fainting spell or something, and that's what caused her to leave her last job?
Yeah, I would have to look that up. I'm not totally clear on that right at the moment. During my break, I'll concentrate on that. This is the kind of job, though, that if you are a migraine sufferer or a chronic headache sufferer, it eventually will aggravate it. It's like our work that we do. In fact, I'm a migraine sufferer, and the only reason I can work is that I'm the boss, and so I can determine which 10 hours of every day I work, or 14 sometimes. But when people are in jobs that are regimented 8 hours a day, 5 days a week, and they don't have a choice, then migraines interfere with the ability to do work. I do think that there's some artful hyperdefinition of the impairment here. Yes, the claimant has vertigo, but the claimant also has chronic headaches, well documented, and in essence, the impairment is migraine with vertigo and extensive nausea, vomiting, and dizziness. The ALJ focuses on vertigo, but that then means that the functional limitations can be centered upon postural or exertional rather than endurance limitations like absences or breaks. So, I mean, there was a targeting. And I know that I do say in the brief that migraine should have been designated severe, but regardless of whether it's designated as severe or not, it's still, a non-severe impairment can support limitations. And here the limitations are absences and unpredictable breaks.
Mr. Forbes, during
Yeah.
her testimony at the hearing, did she bring up or describe the fact that she was suffering from nausea and vomiting, and that hindered her from working?
I don't recall on that. I apologize. I was not focusing as much on the testimony perhaps as I should have. The other point is that migraines wax and wane, and they don't always present the exact same way each time. So you're going to see vertigo, you're going to see headache, you're going to see nausea and vomiting, you're going to see all of them together. I think one of the things that is instructive is the judge's own words here, and I will go to them. There's some discussion of migraine headaches, but claimant's description of her migraine symptoms appear rather atypical. That phrase right there assumes that all migraine headaches present exactly the same way. They don't. Her physician did not propel her towards typical migraine treatments. Well, she'd already tried the typical migraine treatments in the Maxaltia, Imitrex, and the propranolol. Granted, she didn't have Botox treatments, but that's her physician's job. And it doesn't appear that migraines are a formal diagnosis. Well, I mean, how many times does it have to be mentioned in the record by a physician before it becomes a formal diagnosis? And if the ALJ is suggesting that gives the administrative room in order to declare it not a proper impairment, that's just incorrect. And then finally, there's a statement in here that suggests that the fact that migraine medications did not work means that it wasn't a migraine impairment. But that's that borders on ridiculous, because there are the diamond headache here in Chicago would not exist or be needed if migraine medications always dealt with the problem. So that is a statement made by the ALJ that has no logical connection to what's going on here. Why would that statement be made? And as I suggest, there's an attempt here at hyper-definition of what's going on in order to support an RFC that does not include the absence and limitations. So I will reserve the rest of my time. Thank you.
Thank you.
Yeah.
Ms. Jeffrey.
Good morning. May it please the court, I'm Kia Jeffrey, representing the Commissioner of Social Security. The ALJ's decision in this case is an example of the proper way to evaluate an impairment that's not severe. The ALJ explained that migraines were non-severe because treatment records in this case were unclear, but she still considered the impairment throughout the rest of her decision. And she included residual functional capacity limitations to address the most prevalent complaint in the record, which was vertigo. First, to address McCorkle's arguments regarding the diagnosis itself. Initially, I'd like to note that McCorkle's arguments emphasizing the diagnosis itself are misplaced. The diagnosis does not show the severity of the impairment or the functional limitations that it would cause. And the ALJ did provide good reasons for finding that there did not appear to be a formal migraine diagnosis in the record.
Yeah, I don't know about that. I know the ALJ said that that observation is correct, but when I took a look at Dr. Frazier's records, migraines are all over him. It's everywhere. And so for him to be observing the migraines and trying to help Ms. McCorkle with them, it seems to me that it's a diagnosis. just over and over again that way. And as her primary care physician, Frazier went further and he came forward with those letters, right, saying the migraine problem is severe enough that I don't think she can work that way. And I'm concerned about how the ALJ handled that. Because you're definitely right. Vertigo is all over this too. The vertigo issue seems sufficiently dealt with the cane, because it goes to the dizziness, the imbalance, all of that. But the cane is not an accommodation for the migraines, right? Because Ms. McCorkle testified that the migraines knock her down. You know, she's got to lay down, and she's got to lay down in dark rooms that way. So what's your reaction to those observations?
Your Honor, I think one point I'd like to make is that in actually looking at Dr. Frazier's treatment records, he did appear to have some questions about the diagnosis at different points. In one record, he noted that the headaches might be more tension-related rather than migraine. And in one of the opinions that you noted, he wrote either chronic headaches or migraines. So there did appear to be some question in the record from Dr. Frazier regarding the proper diagnosis. But Your Honor is correct. There are several mentions of migraines. And to the extent that the court were to find that the ALJ should have acknowledged that diagnosis as a formal diagnosis, there's still no reversible error at step 2, because the ALJ continued to consider Ms. McCorkle's headaches throughout the rest of her decision and consider how they would impact her functionally. Your Honor noted the residual functional capacity limitation, including a cane. The ALJ also limited Ms. McCorkle to sedentary work, requiring her to stay seated, no climbing of structures, no working at heights or around machinery. And the reason those limitations are important and that they also address the headache issue is that when McCorkle complained of headaches, she often complained of dizziness and lightheadedness. We don't really see any separate limitations that are occurring from the headaches. She did testify to having 3 to 5 migraines per day and having to lie down for those migraines. However, when we look at Dr. Frazier's treatment records, she wasn't making those same complaints to Dr. Frazier during her treatment. She more so indicated that the headaches were more of an episodic type of symptom that didn't really impair her daily life.
He thought they were enough, though, to keep her out of work at least 5 days a month. And if there's about, how many working days a month? About 20?
Yeah, that
So
sounds right.
5 out of 20 is a meaningful number, is it not?
Yes, it is, Your Honor. But the ALJ gave good reasons for finding Dr. Frazier's opinions only partially persuasive. She noted the fact that Dr. Frazier's own examinations were essentially normal. She noted the fact that McCorkle's complaints to Dr. Frazier about headaches were different from how she testified to extremely severe symptoms during the administrative hearing. And ultimately, the ALJ's residual functional capacity finding was supported by state agency physician opinions, and those physicians had the chance to review her treatment records up through March 2019, which included Dr. Frazier's treatment records and McCorkle's complaints of frequent headaches. So the ALJ actually went beyond those opinions and found that McCorkle did require the use of a cane to address her other
When the
symptoms.
ALJ says he doesn't, or she didn't see any indication of a referral for more typical migraine treatment when the migraines are quite intense and persistent that way, how does the ALJ have any idea what typical migraine treatment is? Isn't that it's a medical question, is it not?
It is, Your Honor.
I didn't see anything in the record about the different treatment options when somebody is really suffering from migraines. I'm sure that the treatment can become more progressive and advanced, but I don't know how an ALJ would know that without medical evidence, any more than you would know it or I would know it.
Yes, Your Honor. I think, and I'm trying to find it here in the ALJ's decision, what the ALJ was referring to was the fact that McCorkle had been referred to a neurologist, and there was no evidence that she actually followed up on that referral. And in addition, there was the testimony from Ms. McCorkle at the hearing that her migraine medications were not effective, and she ultimately was using Tylenol 3 to treat her symptoms. And the ALJ considered McCorkle's treatment as just one factor in her analysis of the entire record. It wasn't the defining or the most important factor that the ALJ considered to determine whether or not her impairment was severe and whether or not it required additional functional limitations here. If the panel doesn't have further questions for me, I would just reiterate that the ALJ properly considered the impairment. Even if the court were to find that the ALJ should have found that migraines was a formal diagnosis or was severe, the important question is whether or not the ALJ formulated a residual functional capacity finding that incorporated all the limitations that are supported by the record. And we would submit that she did. So we ask that.
Do you have a thought on that question I asked Mr. Forbes about? Do you have any recollection from, I know you know the record well, anything about the migraines worsening over time?
Your Honor, I don't believe there's any records showing that the migraines worsened over time. And as you noted, it is an important factor to note. You know, McCorkle has emphasized the fact that she had a very long work history and that she stopped working, but she did have that long work history while having these migraines. And the ALJ found that she could return to her past relevant work here.
Thank you.
Thank you.
Thank you. Mr. Forbes.
I believe at record page, administrative record page 46, that's the old-fashioned enumeration, not the official court enumeration. You will find, yes, that she was fainting at her desk, but that things were getting worse. And I think the headache is mentioned there. I did not find the words nausea or vomiting at the hearing. In fact, when I did my analysis of the medical records, it shows up sometimes as yes, it's happening, and other times it's not, which is actually, I think, consistent with the presentation of migraines. It does not always fit the textbook presentation. I mean, it varies per the individual. This is close. It's a close case. Almost all migraine cases are close cases because of the way that they're diagnosed. And ultimately, it does boil down to whether the limitations and absences or triggers or the traditional symptoms are whether they prevent work. Let's see what else.
Mr. Forbes, your time has expired, so if you could wrap up.
Hard worker, that's got to amount to something. And people just don't leave jobs when they've spent their lives doing them. And sometimes it just boils down to the person in that position when they say they're disabled, they really are. So, thank you.
Thank you.
Thank you.
Our thanks to both counsel. The case is taken under advisement, and we'll move to our third case this morning, United States versus Corey Williams. Mr. Robinson.
Good morning, and may it please the court. My name is Matthew Robinson on behalf of the appellant, Corey Williams. Mr. Williams is a nonviolent drug offender who pleaded guilty and accepted responsibility. He's subject to a 20-year minimum mandatory sentence, and I think it was September of 2017 when he was sentenced. He was subject to that sentence because of his prior record. He's not running away from that. He had a prior a prior felony conviction for possession of a controlled substance on his record, and that allowed an increase in his statutory minimum to be 20 years. At the sentencing hearing, however, his guideline range was 135 to 168 months. Quite a big difference. However, the judge, rightly so, was restricted by the minimum mandatory and gave him that sentence. In the time period since Mr. Williams had been incarcerated, and it's been several years now, he engaged in rehabilitative efforts and eventually discovered that he could file a motion for a reduced sentence as a result of the First Step Act, which was passed in 2018. Obviously, the issue in this case is that the district court, in deciding his motion, felt that it was not allowed to take into consideration the change in sentence.
Mr. Robinson, we're going to have to take a short break right now. I'm sorry to interrupt your argument, but the
No
court
worries.
will be in recess for just a few minutes before we continue with the argument. Thank you. All right. You may proceed, Mr. Robinson.
Thank you. And that leads me right to the point of probably why I'm here. Obviously, the Seventh Circuit in this court has held that these non-retroactive guideline amendments and changes in law that occur after someone's sentence cannot be extraordinary or compelling circumstances under 18 United States Code Section 3582C1A. We recognize that, and as a matter of fact, I am preparing for today. I saw that the Seventh Circuit issued a decision called United States versus Perham, I believe, on December 5th, kind of defeating what I've argued here, but I'm going to make my case because I think it's still distinguishable. First of all, the Thacker, King and Thacker, in my opinion, are wrongly decided, respectfully, and are contrary to the decision in Supreme Court's decision in Concepcion. The Seventh Circuit's position conflicts with a canon of construction, expressio unius, forgive my pronunciation, whoever knows exactly how to pronounce it. However, the expression of one thing typically means the exclusion of another. And with respect to these First Step Act motions for a reduced sentence, there's only one factor that the court that Congress saw fit to say couldn't be considered as a factor, and that is rehabilitation alone. Everything else is left out in the open. Now, granted, that's partially because there's no policy statement still left in the United States guidelines about this, and hopefully that'll be changing. However, the law as it reads today, in King, it fails to engage the key language from Concepcion, which was essentially that nothing express or implied in the Fair Sentencing Act prohibits or restricts a court from considering non-retroactive guideline amendments to help inform whether to reduce a sentence or by how much. It is only when Congress limits the scope of information that a court may consider that a district court's discretion to consider that information is constrained. That's a quote from Concepcion, 142, Supreme Court at 22396. I realize that argument on itself is foreclosed by circuit precedent, but I think it sets up the next part of the argument, which is important here factually. In Mr. Williams' case, even if the Seventh Circuit's position on this issue can be reconciled with Concepcion, the district court erred in denying Williams' motion because the court failed to address the disparity in punishment that is specific to his case. And we can do that because he had a co-defendant in this conspiracy, Mr. Shivers, who, prior to Mr. Williams filing his motion for reduced sentence, also filed one, and it was granted. And it was granted before the Seventh Circuit had prohibited courts from considering these factors like this. Now, these defendants were of the same relative culpability in the conspiracy, and we know that because the pre-sentence report in Mr. Williams' case, does not provide for any enhancements for Mr. Williams, and also, and when I say enhancement, I'm talking about leadership enhancements or role enhancements. And the two defendants were culpable for the same amount of drugs, everything the same except for criminal history for the most part. And the district court did not address this disparity in denying his motion. Instead, it felt constrained by the belief that it was not allowed to consider whatsoever the changes in penalties that occurred. So with that, we would ask that the court vacate the district court's decision and remand this for further consideration so that the court can exercise its discretion. Because at this point, the district court felt its discretion was restrained and improperly. Unless the court has further questions, I will leave the remaining for rebuttal.
Thank you.
Thank you, Your Honors.
Ms. Mendrum.
May it please the court. Good morning. Assistant United States Attorney Marianne Mendrum on behalf of the appellee of the United States. The court should affirm the decision of the district court. And it's the government's position that the district court did not abuse its discretion when it denied the petitioner's motion for compassionate release. Specifically, the threshold issue here, and the only issue on appeal, is whether the non-retroactive changes to the statutory mandatory minimum sentence constitutes an extraordinary and compelling reason to reduce a sentence. And under this court's precedent, as both petitioner as well as appellee has admitted to, they do not. The petition, now, the government does rely on its brief with respect to this threshold issue, but would like to make a few points with respect to what the petitioner brought up. First, the petitioner, in discussing the disparity issue, did not appeal the disparity issue. It's the government's position that any of the other reasons that the petitioner sought out for extraordinary and compelling reasons were addressed by the district court, and the only issue on appeal, as stated in the petitioner's briefs, was this retroactive, was the issue of the non-retroactive changes. So any arguments regarding the medical issues of the petitioner were addressed by the district court. The rehabilitative nature of the petitioner was addressed by the district court, as well as it's the government's position that the disparity issue was likely not addressed by the district court because it's a 3553A factor that the court never reached. In this case, the court found that no extraordinary and compelling reasons existed for under the compassionate release statute, and as this court has recognized in the Thacker case, it's a two-step process. First, they have to acknowledge whether or not there is the extraordinary and compelling reason before we would even get to 3553A. And the district court rightfully found that we don't get to 3553A because there were no threshold steps to take.
There's a circuit split on the Thacker question, for lack of a better way to describe it, post-Concepcion. Is that right?
Yes, Your Honor.
So what's the weight of authority as it stands right now?
Right now, it's the government's position. Well, it's the government's position that the petitioner waived any of those arguments because the only issue he brought up on appeal is the retroactivity and tried to merge the other issues under that single argument.
Well, right. It's the Thacker argument. The defendant is arguing that we should overrule Thacker in light of Concepcion.
Yes, and it's the government's position that Thacker was correctly decided here.
Right. I was asking about the where the circuit split stands now. How many courts on which side of that question?
Your Honor, the government, the United States is not prepared to answer
Okay,
that
you don't know
question.
where
I don't
things
know
stand.
where
Okay.
it stands right now.
That's fine.
But we believe at least that we fell on the correct side of the law with respect to Thacker. And for those reasons and the reasons set forth in the United States brief, we would rest on its brief unless the court has any further questions.
All right. Thank you.
Thank you.
Mr. Robinson.
Thank you, Your Honors. I'll make this very brief. It looks like the circuits are lining up the same way they lined up before Concepcion as to whether or not. So the Fourth Circuit says, of course, Concepcion says we're doing this right. The Seventh Circuit says, well, Concepcion doesn't affect our analysis. And I also, so those cases are USA versus Bryce. They're cited in my reply brief. It's a case out of the Fourth Circuit, USA v. Chen, which is out of the Ninth Circuit, and USA versus Amato out of the Second Circuit. All of those cases tend to say that Concepcion changed the landscape and to the favor and to show that they were correct, in other words.
Mr. Robinson, I greatly appreciate your candor about Thacker and Kane, both in your briefs and in the courtroom. What's the best argument? Forget Thacker and Kane. Just set them aside for a second. It seems to me that the First Step Act, as informed by Concepcion, is quite different than the compassionate release statute. One thing about Concepcion is the court makes clear that it's effectively plenary resentencing when an individual qualifies for First Step Act relief, right? And that's what prompted the dissent to say, well, it shouldn't be, but that's the heart of the majority's opinion. But the compassionate release motion, even for somebody that does identify an extraordinary and compelling reason that would justify a reduction in sentence, does that, in your view, create plenary resentencing? That's a distinction in my mind that is important. I mean, you might disagree, but that's to say that the First Step Act and the compassionate release statute are, completely synonymous or coterminous with respect to what they open up. I'm not sure about that.
I would say that with respect to the compassionate release statute, first of all, the term compassionate release only came about as a result of the COVID issues, and originally this was a motion that was only filed by the Bureau of Prisons.
Right. So if somebody shows, for example, their health, right, that they have an extraordinary and compelling health circumstance that would warrant a sentence reduction, many did. Okay. That doesn't reopen everything from the original sentencing, right? And that's
agree with
what's
you.
distinct from the First Step Act. I mean, that's what Concepcion tells us the First Step Act is doing. Over a dissent, to be sure, but the majority controls.
I agree with your concern, but I disagree with your perspective, Your Honor, respectively. This is not a full resentencing. This is the permission for a district judge to exercise their discretion at the appropriate time as to whether or not to reduce a defendant's sentence. It's not a full resentencing. Now, the Concepcion evolved from the changes in the crack laws. The Fair Sentencing Act was modified by the First Step Act, and certainly I understand the difference there. However, without any congressional guidance, your concerns are valid, Your Honor, but I think that they're allowed. I think the court is allowed to take into consideration almost any factor that it feels is extraordinary and compelling in a given case. And in this case, the juxtaposition of Mr. Williams and his co-defendant, Mr. Shiver, which I will say is argued within both briefs. I agree I didn't make a separate issue out of it, but it's within the whole context of it. So with this, we will ask the court to remand for reconsideration. And I thank you very much for your time. Thank you, Your Honors.
Thank you. Our thanks to both counsel. The case is taken under advisement. We'll move to our next case this morning, Nalini Badani versus Robert Wilkie.
Good morning, Your Honor. Phil,
Just
Your Honors.
hold up 1 minute so everyone can get seated here.
Sorry, I should say already. I apologize, Your Honor.
All right, go ahead.
May it please the court. My name is Philip Holloway. I represent Dr. Nalini Badani in her appeal. As most employment law practitioners, as well as most judges, including the panel here, understand, discrimination and retaliation suits often turn on whether the defendant's proffered non-discriminatory reason is pretextual. In other words, is it worthy of credence? This case is no different. The agency claims that it terminated Dr. Badani on March 20th, 2017 for 3 reasons. The first of those was performance, the second, her attendance, and the third was conduct unbecoming for a single incident that happened on February 10th, 2017. With respect to performance, the key facts here are that on October 31st, 2016, Dr. Solomon, who was the proposing official, awarded Dr. Badani a 95% performance bonus, which was 95% of the maximum performance bonus.
If we could just, before you go any further on the pretext question, if we could just clarify what's at issue or what remains at issue. I believe it's just the retaliation claim.
Correct, Your Honor. And
the protected activity that forms the basis for the retaliation claim comes in 2 forms. One is the complaint that she raised about how she was being treated with regard to her sick leave during the fact-finding proceeding that her supervisor held, if I'm recalling the record correctly. And then the second category of protected activity would be the formal EEOC complaint. Those are still live issues?
That is correct, Your Honor.
Okay, so let's talk about why each of those would be protected activity. Clearly, the EEOC formal complaint would be protected
Correct.
activity. I think there's a debate about whether the things that she said during that fact-finding hearing about being harassed for her sick leave was a complaint about discrimination based on disability.
Well, that's the February 17th, 2017 fact-finding. They addressed a number of issues, one of which was an altercation that occurred between Dr. Badani, alleged between Dr. Badani and Dr. Bermudez, and also, unbeknownst to plaintiff prior to the meeting, Dr. Badani prior to the meeting, the issue of her sick leave was raised. And it is our contention, appellant's contention, that her statements during that meeting to Dr. Bermudez and Dr. Solomon constitute a protected activity because she linked the issue with sick leave, so-called sick leave abuse, directly to her various medical conditions, which she lists and states in writing in the record, which we've repeated in the briefs. It's our contention that that is protected activity because she placed Dr. Solomon and Dr. Bermudez on notice that she was complaining about their treatment of her based on her conditions. Now, there were other exchanges between the parties during that fact-finding meeting that may not be considered protected activity, but there's nothing in the law that says you can't complain about other things or other factors alongside disability discrimination in order for it to constitute protected activity. And the agency points out that our client didn't engage in protected activity on February 17th, as does the district court, because she didn't say or explicitly bring in disability as a reason. And as we point out in our reply, protected activity regarding disability is of a different color, a different nature than that regarding race or gender. This court has said several times that the plaintiff or prospective plaintiff doesn't have to use quote unquote magic words. And that would apply even would apply with more strength with respect to disability because, as we point out in our argument, the term disability is a legal term of art that lawyers understand, that judges understand, but the general public doesn't really know what that means. They would just go to their employer or the general public that's an employee would go to their employer and say, look, you're messing with me because I'm sick all the time. Or you're doing this to me because I'm ill all the time, or because I have migraines, or because I have, I'm using a wheelchair. You're holding that against me. Regular people don't know what to say. You're doing this to me because I'm disabled. Now, most people would know what to say. You're treating me this way because I am a woman, or because I'm African American, because those are, fairly lay people will understand that. So that's why it's our position that her comments to Dr. Bermudez and Dr. Solomon on that date constitute protected activity.
Can I ask you a question about another aspect of that meeting? Is there any evidence that would permit a finding that Mark McGill, he's the fellow that ultimately conveyed the termination, right? Was he aware of what transpired during the February? I know he wasn't present for the meeting, but what's the evidence show with respect to his awareness of what transpired during the meeting?
The evidence file contains the transcript, evidence file, which is at record 77-4, 876 to 1026, contains the transcript that I'm referring to of the exchanges between the doctors during that meeting. So he would have been aware after reviewing the evidence file of what happened at that meeting just by reviewing the transcript.
Okay, and is the record clear that this transcript from that fact-finding meeting, is it clear that was part of the evidence file?
It is, Your Honor.
Okay.
Mr. Holloway, looking at the transcript of that, or the record of that meeting, I think you seem to be pointing to the statement where Dr. Biondi says there's been a pattern of harassment about sick leave. I'm just trying to get some clarification. Does your client believe that she was being harassed because she took too much sick leave, or was she harassed in that her supervisor did not believe that she was actually sick when she was taking the leave? And does that distinction matter in your mind?
I don't believe it matters, but to answer your question, I would say it's both. My client is complaining both that, and mind you, this is not just a one-off event between the two parties, between Dr. Solomon and Dr. Badani. This had been going on for several years, beginning in 2013, where Dr. Solomon complained about my client needing an accommodation for not using a lead apron because of her sciatica or other medical conditions. So this is a long running issue between the two of them, and it's our position that our client at that point during that meeting felt and communicated to Dr. Solomon and Dr. Bermudez that she was being singled out because of her use of sick leave, which of course, as she pointed out, was because of her several sometimes debilitating health conditions.
What is your best evidence with regard to your position that the EEOC complaint was something that caused or contributed to the termination?
It's several items, Your Honor. First off, our client filed her formal complaint 5 days after the February 17th fact-finding, and then filed her formal, or at least the evidence isn't completely clear as to when Dr. Solomon learned of this complaint, but it was at the very least no later than October 10th, which is the same date that the mysterious October 10th letter that didn't result in my client being terminated. There's another one that was drafted on March 20th. That's one factor in that. Well, another factor is also that Mr. McGill, Director McGill, just on February 16th, 2017, had awarded or signed off on the October 31st performance bonus. And then after he notices or receives notice of Dr. Badani's complaint, turns around and fires her because of performance without any evidence or any data in the evidence file presented to him regarding any negative performance or attendance issues. Your Honor, I would like to reserve the last minute of my time for rebuttal. Thank you.
That's fine, thank you. Ms. Yoon.
Good morning. Lisa Yoon representing APALE, the Secretary of the VA. May it please the Court. This case is about the VA's termination of Dr. Badani after 4 years of subpar job productivity, spotty attendance, and poor attitude, and 4 years of repeated counseling by her supervisor, Dr. Carol Solomon. Then, Badani instigated an altercation with another supervisor that resulted in an official administrative investigation. Because all of this occurred well before Badani filed an EEO complaint on February 22nd, 2017, no reasonable jury could find that she was terminated because of it. I want to emphasize 2 key points that could resolve this appeal. First, complaints about general mistreatment and sick leave do not constitute protected activity as a matter of law. And second, Solomon's termination recommendation and the evidence file were complete and out of her hands before she found out about Badani's EEO complaint. The first point relates to the official administrative investigation. Because the timing of the EEO complaint failed to support Badani's retaliation claim, she asserts that she engaged in protected activity during a February 17, 2017 fact-finding meeting. That meeting was part of an investigation into Badani's conduct several days earlier when there was an altercation between Badani and a supervisor, Dr. Miriam Bermudez, that involved Badani yelling at Bermudez. At that meeting,
So, Ms.
Yes,
Yoon, I'm sorry to interrupt, but when I look at this record, and we're, of course, here on summary judgment, right, which means that all reasonable inferences should be drawn in the non-movement's favor. And I look at these letters that Solomon wrote on February 24th, 2017, and March 16th, 2017, with regard to concerns about sick leave, right?
Yes, sir.
And then I look at Solomon's affidavit that says that basically, he decided that termination was appropriate basically immediately after the February 17th meeting.
Yes, Your Honor.
And yet the letters that are dated after that do not mention termination. In fact, Solomon says, you know what, this is a continuing issue that you need to address, and we're going to revisit this issue in September. And so how are we to reconcile those kind of disputed issues on this record?
Your Honor, I would submit that they aren't disputed issues. The letters are what they are. However...
Well, the letters contradict what Solomon said in his affidavit, right? So Solomon said that, after the meeting, I determined that we need to terminate Dr. Badani based upon those 3 things. And then yet, in a subsequent letter, when he mentions one of those 3 things, there's no mention of termination at all.
So one key fact that's important here is that Solomon did not have the authority on her own to terminate Badani. So she has to, as Badani's direct supervisor.
Right.
make
So
her-
even if Solomon didn't have the direct authority, one would think that, and so let's say was going to recommend the termination, one would think that a subsequent letter would at least refer or mention that that was a potential.
Your Honor, the government would respectfully disagree with that. To give someone who might actually be a colleague notice that you are trying to fire her at that early juncture when she did not know that her recommendation was going to go through and be approved, that is not a reasonable inference to make. Also, kind of looking at it big picture, she did say that she issued the February 13th letter and then reissued it later to make sure it was part of the file. And the record is really undisputed that all this activity is happening before she finds out about the EEO complaint. So, and going back to that point, appellant's attorney said that, and it's not clear in the record, that the date that she found out about, or that she found out about the EEO complaint. However, it is actually really crystal clear in the record. Badani states that the director of the VA, Mark McGill, received the evidence file between March 6th and March 10th. And then Solomon, for her part, was not notified until Badani's EEO complaint until March 10th. Any suggestion to the contrary in the reply brief is simply incorrect. The record is very clear on that. It is actually part of the district court briefing, and it's one of plaintiffs, in that matter, plaintiffs' proposed facts. So all of this activity is happening. She does not know about the EEO complaint. And so what we're talking about here is when was Solomon made aware? She's always been kind of set forth as the bad actor here, the one with discriminatory or retaliatory animus. When was she aware that Badani was making such a complaint? And, you know, what her actions were.
And you don't think she was aware when Badani during that meeting said that you were harassing me for sick leave?
That's a good question. No, Your Honor, it's not. So at that meeting, Badani complained that she was harassed by Solomon. Specifically, she was saying that Solomon harassed her for her sick leave, for her productivity, for her RVU numbers, and generally efforts to supervise her. But this court has held that complaints about sick leave and the discussion of health conditions in the context of sick leave do not constitute or do not implicate disability, retaliation based on disability. So, and in her reply brief, Badani tries to distinguish McHale by saying, oh, I actually listed out my health conditions. Whereas the plaintiff in McHale said that she suffered from several very serious health conditions. But it's not the identification, it's not the magic words. That's not the issue. What is important is the assertion that something happened because of the disability. So the court in McHale explicitly stated that the charge, whether formal or informal, must be about the discrimination, and the complaint must indicate that discrimination happened because of a protected class. When you look at the meeting transcript, Badani simply was not saying that Solomon was harassing her because she was disabled. That is at the district court record 77-4.
You don't think that it's even possible for a jury to construe that transcript otherwise?
No, Your Honor.
Because she's linking, before she complains about the, being harassed on the basis of the use of sick leave, she's itemizing her health conditions. And
Yes.
she's emphasizing that the sick leave I took was because I'm sick.
So, as in McHale, yes, she's itemizing them, but the prompt, the question is, she's responding to why she's taking sick leave. So she is talking about her sick leave usage, which necessarily will always 100% time, when there's a meeting about sick leave, someone asks you why you're taking sick leave, there's going to be presumably.
But the very fact that we have to have a dialogue about what inferences to draw from it, doesn't that suggest it's a jury question?
No, Your Honor. I think it's very clear here, just like in McHale, that there was no indication that Solomon was saying, that Badani was saying that Solomon was harassing her because of her disability. She was saying that Solomon was harassing her for general supervisory efforts about productivity, RVUs, and sick leave. And I will say also, if
Ms.
the-
Yun, what if and she had said there's been a pattern of harassment about sick leave that I've taken because of my hypertension, high cholesterol, and kidney stones, degenerative disease.
Your Honor,
Would that be different?
just so I have it clear, so if Badani were to say there's a harassment based on my sick leave use for these particular
Yes.
conditions, no, Your Honor, that wouldn't be different. There really has to be a charge, and this is why the formal charge is so clearly, the formal EEO charge is so clearly notification of hey, I'm asserting my rights here, that you are violating my rights because of my disability. They're talking about like an administrative type complaint, like I'm taking sick leave for these reasons. You're harassing me. It's very clear that the harassment that she was complaining of has to do with her taking sick leave, but more specifically the pattern of sick leave that she was taking, as well as other issues. She talked about her productivity, RVUs, and just generally efforts to supervise her. And I do want to go back to, if the court were to find, which the government disagrees with, that it's not clear that she simply was not alleging that she was being harassed because she's disabled. But even if the answer was not in the government's favor on that point, the only argument that appellant has is that timing alone, because Solomon has stated that she made that decision right after that meeting, timing alone shows the retaliation. We actually have to then consider the three reasons that the VA has put forth, the three legitimate non-discriminatory business reasons that the VA has put forth for Badani's termination. The VA identified these with specificity and citation to the record. There's performance, attendance, and misconduct issues. And Badani must refute each one individually.
Isn't attendance just a proxy for what we're talking about? Misuse of sick days?
Yes, attendance issues,
So
exactly.
it just circles back to the same dialogue we've just been having.
No, I believe that we still have to look at, was this a genuine reason why Solomon decided to terminate Badani? Again, and we're talking about sick leave, a concerning pattern of sick leave that dates back to 2013. So it's easy to kind of zoom in on that short period, but we are talking about a history that's documented of her misuse of sick leave, as well as her performance issues and her productivity issues. So all of these issues, the conduct and attendance issues are in the evidence file. My apologies, I didn't realize my time had run out. And the productivity issues are certainly not in the evidence file, but there's nothing actually about performance or productivity. But Solomon was aware of Badani's issues as a direct supervisor, and the termination originated with Solomon. There was enough evidence in the evidence file for McGill to approve. So there's no evidence that the termination was retaliatory. If this court has no further questions, the government will rest on its brief and respectfully request that the court affirm the district court.
Thank you.
Thank you.
Mr. Holloway.
As much time as I have left, I'd like to address 3 points. The agency's counsel argued that there was a history of documented attendance. However, that history ends on November 18, 2016. That is the last sick day that's referenced in any document in the record, period. It's also 4 days, before Dr. Solomon recommends my client be reapproved for employment for 2 more years. So if it wasn't worthy of discipline on November 22nd. Instead, it was worthy of being re-upped for 2 more years. Then it shouldn't have been worthy of discipline after our client engaged in protected activity in March of 2017.
I have a question about the evaluation of the protected activity here, the complaint about the harassment for her sick leave during that fact-finding meeting, which is the first category of protected activity being asserted here. From whose vantage point is that evaluated for reasonableness? From the vantage point of the speaker or the vantage point of the supervisor who heard the complaint? The standard is that a reasonable person would have recognized it as a complaint about disability.
Right, it would have to be, under the law, it would have to be the listener. And in this sense, Dr. Solomon.
Okay, so what's your best argument that a reasonable person in Dr. Solomon's position would have recognized this as a complaint about disability rather than a complaint about the truth of her use of sick leave?
It goes back to the argument I made originally in response to Justice Lee's question that most people, when they engage in this sort of dialogue, we know what someone's talking about when someone's speaking to us. And
Right,
her actions after that.
Yeah, but this is a little more complicated because it concerns the use of sick leave, and the allegation that was being leveled at her repeatedly over the course of several years is that she was abusing sick leave. In other words, taking it when she didn't need it, when she wasn't actually sick. So it was a complaint about her truthfulness in taking sick leave rather than what she was taking it for, if you understand the distinction that I'm driving at here.
I understand the distinction, but I would say that, and I believe that Dr. Solomon pointed out in her deposition, that she approved every one of those sick leaves. So it wasn't a question of truthfulness, it was just a question of use, period. And that's what my client was complaining about.
Okay, I think I understand the argument now.
Thank you. And we'd ask that the court remand.
Thank you very much.
Thank you.
Thanks to both counsel. The case is taken under advisement. We'll move to our next case this morning, United States versus Bryant Love. Mr. Brown, good morning.
Good morning, and may it please the court. Attorney Russell Brown on behalf of Mr. Bryant Love, the appellant in this matter. Your Honors, I believe the first matter of business is to address whether or not the court should even address this issue. And it's Mr. Love's position that the United States Supreme Court decision in Borden amounts to a change in substantive law for the circuit. Specifically, Borden held that the ACCA's definition of violent felony does not include offenses criminalizing reckless conduct. Rather, the violent felony only covers purposeful and knowing acts. Prior to Borden, this circuit's precedent was clear, with Dickerson and Clickno, that the Illinois armed robbery statutes back in 1992, the same terminology and verbiage used of Mr. Love's armed robbery conviction was in fact a predicate offense under the ACCA.
Without addressing the mens rea question.
I'm sorry, Your Honor?
Without addressing the mens rea question. The more specific question here is whether the law of this circuit was consistent with the holding of Borden, which is that recklessness doesn't count under the ACCA. It has to be purposeful or knowing conduct.
Correct. And that's what the government's reliance upon Rutherford and this court's decision in Rutherford about talking about the mens rea and reckless conduct. But in Rutherford, the court utilized, while it did talk about reckless conduct or accidental conduct in that opinion, it talked about use and the use of force. And so the Illinois statute also uses the term use. And so it was still precluded.
It wasn't precluded. No one had previously challenged the use of or the classification of the Illinois armed robbery statute, or even the Illinois robbery statute, because the armed component of it just adds a weapon, as not qualifying or properly classified under the ACCA because of the mens rea requirement. That argument was still, I mean, it could have been made under our general precedent, which was long in place before Borden, that crimes with a mens rea of recklessness don't count.
And I understand.
So Borden didn't represent a change of the law in this circuit on that basic question. With regard to its specific application here, with respect to this particular statute of conviction, that argument could have been made pre-Borden.
And understanding Your Honor's position on that, respectfully, we believe that with Dickerson and Clickno, the two prior Seventh Circuit cases where it specifically held that the Illinois robbery statute was in fact a predicate offense under the ACCA.
But without addressing the mens rea argument.
That is correct, Your
So you can see that there's that distinction in those two cases.
I can, Your Honor.
Okay.
So with the understanding Your Honor's comments, the holdings in Dickerson and Clickno made it very difficult, and or Mr. Love's position foreclosed his argument on the initial appeal for whether or not his predicate, or whether or not his armed robbery offense in Illinois was a predicate under the ACCA.
So can you set Dickerson aside for a moment, right? Dickerson is 1990, correct?
That is correct, Your Honor.
Okay, so that's before the huge wave of case law and the categorical approach on it, so forget that for a minute.
Okay.
Okay. Why is it when you read Clickno, within the four corners of Clickno, that the mental state argument is foreclosed? What language in Clickno do you read as foreclosing the argument? Because Clickno, the reason I'm asking that, right, is Clickno, as Judge Sykes is getting at with her question, Clickno is an elements analysis focused on force, the force aspects, right, of Illinois robbery.
That is correct, Your Honor.
Okay. And I think the point that Chief Judge Sykes is making is that, well, sure, force is one aspect of it, but what about the mental state aspect of it too? So what language in Clickno foreclosed Mr. Love from lodging the substance of the challenge that he now wants to lodge?
Our position would be, Your Honor, is just the overarching holding that Illinois armed robbery is a predicate offense under the ACCA. And it was that specific holding that, while, yes, Clickno talked about the various, the force, that specific holding, the ACCA is, Illinois armed robbery statute is a predicate offense under the ACCA. And I would direct Your Honor's attention to Jones v. United States. It's an unpublished decision out of the circuit that specifically stated that specifically held, well, this argument has been foreclosed by Clickno, again addressing the Illinois armed robbery statute. So that's consistent with Mr. Love's position that he could not previously have raised this issue because it was foreclosed by Clickno. As we go through the analysis with the categorical approach, which Your Honors are very well aware of, the categorical approach is, and I quote, "If any, even the least culpable of the acts criminalized do not entail the kind of force the statute of conviction does not categorically match the federal standard and cannot serve as an ACCA predicate. That was cited by United States and Borden, relying upon its decision in Johnson of 2010. The Illinois armed robbery back in 1992 statute that Mr. Love was convicted of allows for reckless conduct. And as this court recognized in Shama,
Well, that's a rather categorical statement. It's an open question, and I think it is a contested question whether what the mens rea under the armed robbery statute or the robbery statute, which is the base offense here, whether recklessness qualifies, right?
the Illinois Supreme Court has, because their statute did not set out a mens rea back in 1992, the Illinois Supreme Court in Jones, also in Aguilar, acknowledged that because the legislature in Illinois did not specifically set out a mens rea in the statute, then any of the mens rea of knowingly, intentionally, or recklessly apply to that statute.
With respect to the use of force component of the statute or the taking of the property component, which one?
Your Honor, that I do not believe that specific question has been answered by the Illinois.
That's what I'm driving at here. The precise question here about what mens rea is required for which elements of the offense is an open question in Illinois under the statute at the time your client was convicted.
I would believe so, Judge.
So we'd be deciding that in a blank slate on plain error review. Not a good idea generally, right?
Understanding Your Honor's belief and position that because Clickno did not foreclose this argument, that it's under a plain error. If Your Honor believes that this argument was foreclosed by Clickno, then I believe that it's a de novo review. So it's Mr. Love's position that the mens rea element applies not only to the takings or the taking of the property, but also to the force that was used in order to take the property.
What did the jury instructions say at the time?
Your Honor, the jury instruction and the government cited to the jury instruction in their brief, and the government used that as support for their argument that it was only for the takings clause. However, I believe that is a too narrow reading of the instruction and or the statute in and of itself. Again, because the statute itself did not include a mens rea, the instruction does not include a mens rea. And so that's where we believe that it is reasonable to make the determination that the mens rea applies to both.
I thought the instruction contained a mens rea, but only with respect to one element of the offense. So the recklessness option was not available for both elements of the offense, the taking and the use of force component?
Respectfully, Your Honor, I believe it is. I
don't have it in front of me, I don't remember, but my recollection was that recklessness option was only with respect to one element, not both.
Well, and I would I guess argue that robbery is about the force. Otherwise, it's just a theft. And as the Illinois Supreme Court indicated in Aguilar, the difference between robbery and theft is very subtle. So when we talk about the mens rea element, force is what matters in order to distinguish that from the theft. So it would be our position that the mens rea of the actual force, the mens rea should apply to the force element as well as the taking element.
Thank you.
Your Honor, I understand that my time is up. Thank you very much for the opportunity. Respectfully request Your Honors to remand for resentencing with direction to the district court to allow the district court to sentence Mr. Love and that the Armed Career Criminal Act does not apply. Thank you.
Thank you. Mr. Whalen.
May it please the court. Good morning, Your Honors. Nathaniel Whalen here on behalf of the United States. Your Honors, this court should affirm Mr. Love's sentence for 3 reasons. This court's already discussed waiver. The second but related issue is the scope of the mandate. This court instructed the district court to remand for resentencing under the Armed Career Criminal Act. The district court appropriately found it could not go beyond this court's mandate and reconsider new arguments. It was obliged to do what this court told it to do, as district courts are. Mr. Love has still not addressed that issue, and we think that that's an alternate basis to affirm. Unless this court has any questions on those, I'll just move on to the substance of Illinois robbery. And Chief Judge Sykes, you're right, the Illinois jury instructions do include recklessness as to the takings element. To the extent that there's any confusion about that, if you look at instruction 14.06, which we don't cite because this is sort of a new argument on reply, Illinois armed robbery has been amended to say knowingly take property through the use of force. And so if you look at 14.06, which is the current instruction for armed robbery, element 1 is the takings element, and it says knowingly take property. Element 2 is identical to what it was back then, which is through the use of force or threatened use of force against another. So they've amended the mens rea as to the takings element pursuant to the statute, but not as to the second element. And that's because the word use is what provides the mens rea as to the second element. And that's what the Illinois courts have said when they've said in, for example, Dennis, that when you use force, you are directing force at the victim. You know, it's similar to what the Supreme Court has done in Voisin and Borden and Leocal, where they've interpreted the word use. Illinois has just interpreted it differently than the federal courts have interpreted the word use as it applies in the Armed Career Criminal Act. Illinois courts have said use means contemplated force or force directed at another individual. And I do think the best example of this is this
As the means for completing the taking of the property.
That's correct, Your Honor.
And that's what distinguishes robbery from theft under the model penal code in most state statutes.
Absolutely, Your Honor. And that's where Aguilar actually comes in. Aguilar is a case about the connection between the use of force and the taking. That's a case where the defendant, the victim sees people in the street, gets out of the car, the defendant and a bunch of people punch him and throw stuff at him, and the victim runs away. They then take his car. He argues to the Illinois courts, no, there's no connection between the two, between the force and the robbery. And the Illinois courts say, no, your force is what effectuated him leaving the car. That basically made the car available for you to then take. So there is that connection, what the Illinois courts call a concurrence between the use of force and the taking.
And that's why you're saying, I think, help me out here, in your red brief, that it doesn't make any sense to think of, if you think of the force aspect and the mental state aspect of force as being contemplated, directed that way, you get yourself tied in a knot pretty quickly if you start trying to inject recklessness considerations into that, right? The point you make is something like, how can you consciously disregard your use of force when you're contemplating and directing the force at a victim? How can you hold that mental state at one and the same time?
That is our point, Your Honor. And the Illinois Supreme Court addressed that in Belk, albeit in a slightly different context. They were talking about forcible felony, which talks about the use of force. And what the defendant in that case said is, I committed a reckless crime. I think it was a vehicular homicide or something like that. And that shouldn't qualify as the use of force. The Illinois Supreme Court said, that's right, it doesn't qualify because you did not contemplate force. And so the Illinois Supreme Court in that context, and we think it's identical to the robbery context, it said use really requires a contemplation of force. And that's consistent with what it said in interpretation of the robbery statutes. And in the Carter case, which we also cited, an appellate court case, the court kind of handled the robbery statute as it relates to forcible felony and says, well, right, the Belk case didn't involve the use of force because that was reckless. Robbery, though, and the quote is, inherently qualifies because it involves the use of force. It involves the knowing or intentional direction of force at another. I'm sorry, Your Honor.
So, no, not at all. So just to clarify in my mind, the appellant raised some hypotheticals, and that, got me thinking about hypotheticals. And so just to clarify, so if a person, is recklessly driving a car down the street, right, and they happen to hit a pedestrian, the driver gets out, sees a pedestrian was carrying a briefcase, takes the briefcase, and then drives off. The state's position is that would not be sufficient to constitute robbery.
Our reading of Illinois case law is the Illinois would say that does not qualify as robbery for the same reason that it did in Belk, that it's a reckless application of force. I don't want to say use of force because obviously that's a phrase that's causing a bit of trouble here. Yes, it's an application of force in a reckless manner that is not actually the use of force.
It's an opportunistic theft.
I think that's right, Your Honor. I think, there is I was trying to think about that example, and there is a recklessness statute. I don't know if Your Honors care about the citation. It's 720 ILCS 5-12-5, which says if you recklessly perform an act that causes bodily harm, I suspect that would be the charge in the case. It would be recklessness plus theft.
Every state has a similar
Sure.
statute.
I am not a scholar in Illinois law or... nor do I purport to be. I just play one on TV, Your Honors.
Right. There's plenty of other things that would be chargeable from that hypothetical.
I think that's right, Your
But
Honor.
it probably wouldn't be robbery or even armed robbery if you considered the car as a weapon.
I think that's right. And I think importantly, neither Mr. Love nor myself have identified a single case where Illinois courts have ever said the reckless use of force does qualify as the use of force under the robbery statute.
Mr. Whalen, can I take you back, set aside the scope of the mandate issue and go back to forfeiture a little bit? Mr. Brown's making the point that, and I think you got to set Dickerson aside. I think Dickerson's kind of from a different era.
I agree with that.
Okay. So Click No is the case to look at that way. And his point is that Click No is pretty express, it's pretty declarative, albeit an unpublished opinion, that Jones case. It looks like we read it that way. What's your reaction to that?
Exactly as the court reacted to it, which is that dealt with the use of force, that dealt with the Stokeling issue, and kind of which interpreted Flores from this court, which is what qualifies as the use of force in terms of the magnitude of the force. The Illinois courts, for example, have talked about taking a purse from someone on the street, and that's the issue in front of this court in those cases. Does that meet the Stokeling standard?
So the other point that comes to mind, and just bear with me here, is that we've been trying to work through the categorical approach cases, we've seen different challenges, have we not, to drug statutes, for example, around what's qualifying as distribution and not distribution, but then we'll see an altogether different challenge about what substances are picked up, right? So you get this whole
Isomers,
cocaine, isomer business and all that kind of stuff. And those defendants would say, well, that's a totally different challenge. I'm not challenging the distribution aspect of this. I'm now focused on what's picked up by the statute.
That's correct, Your Honor. And we think
that's
where a defendant remanded in one of those cases, I think Ruth is the leading case on that in this court about the isomers of I think it's Illinois controlled substance offense. I think had Ruth been a case on remand, it might have come out differently, or should have come out differently, because that's an argument Ruth could have made the first time around. They might have challenged their controlled substance conviction as saying that, it wasn't divisible, for example. If that's the argument on the first appeal, then on remand, they can't come back and say, well, actually, we're talking about cocaine isomers and positional and geometric isomers. That argument we can now raise because we didn't raise it the first time. What this court has pretty consistently said is you can't use the accident.
Somebody had to be Mr. Ruth in the first instance.
Just like someone had to be Mr. Borden, Your Honor. And it wasn't going to come out of this court because this court has never said recklessness qualifies under the Elements Clause. That argument was foreclosed however many years, roughly 30 years ago at this point. So, Your Honors, unless this court has any further questions, we do ask that you affirm this longstanding precedent that Illinois robbery qualifies. Don't create a circuit split with the Eighth Circuit on the issue, and affirm Mr. Love's sentence.
Thank you.
Thank you.
Mr. Brown, your time had expired, but we kept you with lots of questions, so if you have something to say in rebuttal, you may have 2 minutes.
Thank you, Your Honor. I believe that when we're looking at the categorical approach, again, we don't have any specific Illinois cases on point here, but it's what could be the least culpable under the statute. And that's where we get into the hypothetical questions of what it's reasonable. So the government's position is that the force that Illinois indicates that the force needed is be directed at the victim in the case. And respectfully, we don't believe that that is the case, that the force doesn't necessarily have to be directed at the victim. It's force that causes the victim to part ways with the property, but not necessarily directed at that. And that's where Mr. Love posits his hypotheticals of the walking into a crowded coffee shop, acting a fool, maybe waving a gun around, and somebody gets scared and runs out the back. Well, that act was not directed at anybody in specific, but that is what caused the individual to part ways with their property, that the individual then goes and takes off the table and becomes a theft. That would qualify under 1992 Illinois definition of armed robbery. That would actually classify as an armed robbery. And so when we're looking at the categorical approach, it's the least culpable, and we believe that because of that, the statute as applied in Mr. Love's case in 1992 of the armed robbery should not qualify as the ACCA pursuant to Borden, and Your Honor, asking Your Honors to remand and ask the court to resentence him, the district court to resentence him, not applying the ACCA. Thank you very much.
Thank you. Our thanks to both counsel. The case is taken under advisement. And our next case this morning is Carroll versus Horizon Bank. Mr. McQuarrie.
Your Honors, if it pleases this court, my name is Jeff McQuarrie. I represent plaintiff Daniel Carroll. The district court made two errors. The first error was that it found that the executive who fired Mr. Carroll, Dennis Kuhn, did not know of Carroll's advocacy for equal pay on behalf of Allison Esterly Klein. In fact, Mr. Kuhn did know about this advocacy, although he may not have known about it at the time Mr. Carroll was engaged in that advocacy. He necessarily knew about it after the fact. The second error is that the district court impermissibly made credibility determinations regarding the declaration of Cindy Presnell when she testified that the backdated memos, although incorrectly dated and placed in Mr. Carroll's file after he was fired, did in fact describe actual events. I'm going to take the credibility determinations first because those credibility impermissible determinations go to the heart of pretext. Cindy Presnell, the Horizon's vice president for human resources, admits in her declaration that she backdated the three memos, each purporting to describe a meeting at which the executive vice president and she discussed alleged performance deficiencies with Mr. Carroll. She acknowledges that they were backdated and placed in Mr. Carroll's file only after he was fired, but she says that they were based on contemporaneous notes since lost and describe actual meetings. Daniel Carroll, in his declaration, testified that two of those three meetings never happened, and that the conversation described in the third meeting never happened, whether at that meeting or at any other time. The district court found that Dan Carroll's declaration contradicted his deposition testimony and therefore disregarded it. That finding was erroneous. The conversation described in this third memo in the third meeting was that Dennis Kuhn criticized Mr. Carroll for allegedly being rude and inappropriate on a conference call. In his In his deposition, Mr. Carroll acknowledges that a conversation about that phone call did indeed occur. But there is no contradiction because Dan Carroll very plainly testifies in his deposition that Kuhn's criticism of his conversation was as to the substance of the discussion. Dan Carroll felt that extending a loan to this company was financially improvident. Dennis Kuhn wanted the loan to go through. At no time did Dennis Kuhn tell Dan Carroll that his personal conduct or his demeanor was inappropriate. And therefore, there is no contradiction, and the district court was wrong to disregard Dan Carroll's deposition. Those three meetings, if they occurred, are absolutely central to the pretextual reason given for Horizon to fire Dan Carroll. Those three memos describe three meetings at which Dan Carroll received in-person counseling directly from the executive vice president expressing concern about his job performance. In addition, they would constitute written warnings because when a memo is placed in an executive's file, the executive gets a copy of it or gets to see it. If the court credits Cindy Presnell's declaration, then it is essentially acknowledging that Dan Carroll received extensive verbal and written criticism of his job performance. In fact, Dan Carroll testified that, again, 2 of those 3 meetings never happened. The memos were all written after he was fired, so he never received them, never received written notice at any time. And the conversation about his alleged rude and aggressive behavior on a phone call never happened at all. And I might add that Dennis Kuhn was totally unable to remember what Dan Carroll even allegedly said in that phone call. So there is ample reason to doubt that the Presnell memos accurately describe the purported events.
Everything you're talking about, though, isn't it quite separated in time from the issues that were raised about the pay of Ms. Osterly-Klein?
Thank you for bringing that, Your Honor, because I think that gets to a central question. Dan Carroll's advocacy on behalf of Allison Esterly-Klein occurred in the spring, summer, and fall of 2017. That's when he first gave the idea to Human Resources in the spring, presented it to the assembled executives in the summer, in June, and was told, "We like your idea. We're going to reorganize the credit department in the way you describe." And in the fall, Dan is going to the Human Resources ladies, Diane Garwood and the vice president herself, saying, "Allison hasn't been given a raise yet. What's going on?" And is told, "Well, the CEO hasn't approved the raise." Dan Carroll went to Diane Garwood and Cindy Presnell, I think he said 6 or 7 times in the fall. Now, we know Dennis Kuhn probably did not know about that in the fall because he was out on medical leave. But Dennis Kuhn necessarily found out about it afterwards. So when the raise doesn't go through, Allison Esterly-Klein is upset and angry, mainly at Dan for promising her a promotion that she never got. And she complains about sex discrimination to Dennis Kuhn, the executive vice president. Dennis Kuhn finds out about the complaint and schedules a meeting with himself, Dan Carroll, and the vice president for Human Resources. By this time, Human Resources had found out that the entire bank believes that the credit department had been reorganized and among others, Allison Esterly Klein, promoted, but that they, Human Resources, didn't know about it. So at this, and therefore Allison Esterly Klein was promoted to a position that did not exist. At this point, Dennis Kuhn, according to the memo of the Human Resources Vice President, admonishes Dan Carroll for offering Allison Esterly Klein a raise before the formalities of the reorganization had been completed. In this conversation, it is explained by the Vice President for Human Resources that Allison Esterly Klein is complaining of pay inequity. And in fact, we see her complaint in her email where she said that she had come to believe that no amount of talent and hard work would lead to advancement for a female at this bank. In order to address this complaint of discrimination, Dennis Kuhn authorizes the Human Resources to offer Allison Esterly Klein the very job to which Dan Carroll had attempted to promote her months earlier. So I am getting to answer your question, Your Honor. Yes, the advocacy occurred mainly in the summer and fall of 2017. Dan Carroll was fired in May 2018. But Dennis Kuhn did not learn of Dan Carroll's advocacy until late February 2018. He did not learn that Allison Esterly Klein was so upset that she was not going to accept this the peace offering promotion. He would not have learned that until April. So in fact, Dan Carroll was fired a month, not after the advocacy, but a month after the whole situation blew up in the bank's face.
Mr. McQuarrie, your time has expired.
Thank you, Judge.
Thank you. Mr. Cranby.
Thank you, Your Honors. May it please the Court. There's really two issues in the appeal of the summary judgment before you. One of them is what exactly did Mr. Kuhn know? And the other is whether the proffered reason for Mr. Carroll's termination is a pretext. There's no dispute that if Mr. Kuhn wasn't aware of protected activity, that he couldn't have discriminated against Mr. Carroll based on activity he was unaware of. The reason we know that Mr. Kuhn didn't have this knowledge is Mr. Carroll's testimony. He admitted in his deposition that Mr. Kuhn wasn't in that position at the time of the last activity. He was asked in his deposition, when was the last time you engaged in the protective activity? It wasn't quite that legalistically, but that was the question. His answer was in the fall of 2017. Not 2018, not at some meeting later on, but in 2017. Mr. Carroll himself admitted that Mr. Kuhn was out of medical leave at that time. He wasn't involved in any of this process. It wasn't even a supervisor at that time. He was asked in his deposition, was there any occasion when he became aware that Mr. Kuhn knew of this alleged advocacy on behalf of Ms. Osterly Klein? And he said no. So again, the best witness on this point about Mr. Kuhn's knowledge is Mr. Kuhn himself.
Is it even clear that when Mr. Carroll was raising this concern in that fall of 2017 that he was doing it in terms of gender discrimination?
No, I would say it's just the opposite. We're going to come to that in a little bit, but let's hop ahead to it now. What was going on here is he was recommending a reorganization of his department, his credit department, to have 3 regional credit managers, 2 of which were going to be male employees. The third was going to be Mrs. Osterly Klein. And they was told he needed a new salary structure for this. So the idea of what Ms. Osterly Klein was going to receive as part of this package in the reorganization was about the business. It wasn't about making sure things were equal among.
I thought there was
men and women
there's
within the
also
company.
something in the briefs about we not only need to bring her up to speed with the other two folks that are going to have similar managerial responsibilities, just to make them equal that way. But if we don't increase her pay, there's going to be a competitor pick her off.
Yeah, in fact, that's spot on, Your Honor. In a month before this meeting in June of 2017, when the reorganizations kind of rolled out amongst the executives, Mr. Carroll submitted a pay increase for Ms. Osterle-Klein that says nothing about inequality between men and women. What it says is that it's become an extremely favorable hiring market. We're having trouble getting people in. Someone's going to poach her. That was the poach was coming right out of this document. That's at 125 and 126 of the supplemental appendix. So it's clear here if there was really advocacy on behalf of Ms. Osterle-Klein, not because of business reasons or reorganization reasons, but because of inequality, that's when it would have occurred, and it didn't. That's not what happened here. In these two meetings that Mr. Query focuses on, the one in June of 2017, which happened just after the document I just flagged for Your Honor, that was a discussion of the reorganization. It wasn't a discussion of we have an inequality problem here. It was a discussion of we need to fix this department, we need to reorganize to accomplish certain things. The other meeting was in February of 2018, and again, through Mr. Carroll's own words, and this is at the short appendix the supplemental appendix at 321, was they weren't talking about Mr. Carroll's advocacy. They were talking about the complaint that Ms. Osterle-Klein had brought up about why didn't I get the raise that I was promised by Mr. Carroll. He's the one that kind of started this by, without authority, telling the folks that they had gotten promotions, they had gotten raises, but meanwhile the company had said, pump the brakes, we have to run this through the chain, and we have to have human resources look at it, we have to have the CEO sign off on it. So there's nothing in the record, including from Mr. Carroll's own words, about from that meeting that would give Mr. Kuhn any idea that he was advocating for equal pay within the company. I'll move to the pretext issue, and really the argument here is primarily about the backdated memo, so I guess I'll jump to that. Again, the best evidence about those memos comes from Mr. Carroll. His deposition, he testified that there were these meetings. He tries to contradict it in his affidavit. I agree that that's what the record says, that these meetings in March 2018 and April 2018 didn't occur. But at the supplemental appendix 4142, he discusses attending meetings in March or February with Kuhn and Presnell. That's consistent with what the Presnell memo says. And again, we're told that there was no meeting in April at which the tone of Mr. Carroll's behavior on this phone call, well, that's just false. And the reason I can say that is because I have Mr. Carroll's words. I'm going to quote directly from this deposition testimony. Do you recall speaking in April of 2018 with Mr. Kuhn regarding concerns about language and tone you had used on a conference call? Yes, I do. I don't remember if that was the date. I thought it was earlier than that. But you recall speaking with Mr. Kuhn about concerns he had regarding language and tone you had used on a conference call? Yes. Now you're told today that the only discussion was about substance of the call. That's what Mr. Carroll says in his declaration. But he can't do that. He's locked into his deposition testimony. And Judge DiGiulio properly found that in his grant of summary judgment. So on the pretext, the memos don't get there. And I think it's more important than just the contradictions that the substance of the memos are correct. The word backdated is being used a lot to try and create the pretext argument that they're somehow alive. But really what happened here is Ms. Presnell typed in her contemporaneous notes and dated them the day the meetings took place. And they say that Mr. Carroll was warned about his underperforming ways. And Mr. Carroll in his deposition agreed that that's what happened at those meetings. That's the real substance. That's what's important about those memos. But let's look at the argument that the reason for the firing was a pretext. He admits that beginning in the fall of 2017, there were numerous complaints from employees. And these were about serious things. that he was inattentive, that he wasn't managing their workloads, that they were getting overworked, that he was unappreciative, inaccessible, wouldn't return phone calls, and I think really critically, that he was signing documents without them being completely filled out. One of the employees said, we have a regulatory violation occurring here, and we're really at risk. So all of these, Mr. Carroll admitted in his deposition that those were complaints that were in fact made by employees. He acknowledges that he was met with Mr. Kuhn, that he was aware of these concerns, and that Mr. Kuhn had a good faith belief that all those things were true. I mean, this isn't a pretext case where the company's somehow making things up. We know the allegations are true. What Mr. Carroll has to do to prevail in this case is show that such serious allegations that we know were made by Mr. Carroll's own underlings were somehow ignored, and the real intent for Mr. Kuhn's termination decision was something he wasn't aware of that happened way back in 2017, 8 months earlier. There's no factual basis for that. As Judge DiGiulio said in his summary judgment opinion, I understand the arguments, but the evidence just isn't there. And for that reason, we would ask the court to affirm the grant of summary judgment. I thank Your Honors. Unless there's any other questions, I'll release the rest of my time.
Thank you.
Thank you.
All right, Mr. McQuarrie, your time had expired, so the case is taken under advisement. Yes, very briefly, if you have something conclusive to say.
Thank you, Your Honor. Just very quickly, Judge, in response to your question about could Kuhn have known that Mr. Carroll was advocating specifically about unequal pay as opposed to simply increasing the pay of someone that they wanted to keep at the bank. Yes, at the June 2017 meeting where Dan Carroll proposed the reorganization of the credit department, he specifically said that if Allison Esterly Klein were promoted to the position that he was intended for her, that she would be making substantially less than the two other men in that position, and that her pay would need to be increased to their level for the purpose of pay equity. And Dennis Kuhn attended that meeting. Also, at the February...
I think we have your argument. Thank you very much.
Thank you, Judge.
Our thanks to both counsel. The case is taken under advisement. We'll move to our next case this morning, United States versus Jeremy Banks. All right, Mr. Henderson is in the courtroom. Come on up. And I believe Ms. Boyle is on Zoom. There she is. Ms. Boyle, can you hear me?
Yes, Your Honor. Thank you.
Okay, you might have to adjust your camera a little. We're getting like half your face. There we go.
Thank you, Your Honor.
Okay. Thank you very much. All right, Mr. Henderson, you may proceed.
Thank you, Your Honor. May it please the court, my name is Peter Henderson. I represent Jeremy Banks. The question is that in this case is whether police officers may, without a warrant, sneak into your backyard, sneak along the side of your house, sneak to the side of your porch, order you not to go into your house, and then tackle you as you attempt to do so. The plain answer to that is no. Under Florida versus Jardines, the Supreme Court couldn't be clearer that the Fourth Amendment's property-based protections prohibit a police officer from doing that. The property-based approach really was a paradigm shift in Fourth Amendment jurisprudence. So when we look to earlier cases, talking about expectations of privacy, et cetera, there's a lot of balancing involved. For example, the government relies a lot on United States versus Pace, a 1990 case, where the court is trying to balance the expectation of privacy on curtilage versus the police requirement that they act reasonably. And the Supreme Court said that's in addition to the property approach, and couldn't be clearer in the last 10 years. United States versus Jones, Florida versus Jardines, Collins versus Virginia, Lang versus California. Supreme Court keeps telling us you cannot enter the curtilage absent a warrant or some exception to the warrant requirement. Other than for one exception would be a knock and talk. You can seek a consensual encounter with the homeowner, just as anybody might do.
what is the best approach to understanding United States versus Richmond, which was a porch case post Jardines, that seems to authorize a Terry stop on curtilage and focuses mostly on the adequacy of the justification for the Terry stop and the adequacy of the justification for the frisk, as opposed to the threshold question about whether the officers were lawfully present. There's a footnote about consent.
Right.
And maybe that's the key to understanding the case.
It is the key. So imagine a situation where instead of sneaking around through the backyard, the officers here had approached the porch, Mr. Banks was standing there, and they said, "Hey, can we talk to you?" And he said, "Sure, that's fine. It's a consensual encounter."
Mr. Richmond, you mean, not Mr. Banks?
Right. No, I'm trying to make our case like
I see.
Richmond.
I see.
Yeah.
Okay, if that had happened here.
If
I
that had
see.
happened here, this would be a lot like Richmond. And if officers have some reasonable suspicion to believe, at that point the gun wasn't on the grill anymore. I think it was in his pocket. But maybe there's a bulge in the pocket. At that point, Richmond says you can take, in a consensual encounter, you can do a protective search. You're lawfully on the curtilage, etc.
The problem is the facts, as they're described in Richmond, don't really describe a consensual encounter. They describe a pursuit by officers, and there was never a request for consent. Can we come and talk to you? There's no knock and talk, certainly in the nomenclature of the case law.
Right.
They just go up there, but the defendant in that case, and by go up there I mean go up on the porch when he's trying to retreat
Right.
into his home, or at least get rid of the gun into his home. In that case,
And I wondered about why the defendant in Richmond conceded that they were lawfully on the curtilage myself. I think one reason why that concession may have been made is he might have said this was basically hot pursuit, that there was a Terry stop that was permissible on the public way when the police were pursuing him, and so you can't defeat an arrest on the public way by retreating, for a felony offense at least, for retreating.
But it does seem like the majority has the footnote, the Richmond majority has the footnote that Chief Judge Sykes is referring to, and then obviously there's a disagreement in the dissent, but Judge Wood in her dissent also notes the consent point.
Right.
That they were there, right? So it seems to me that if the case is amenable to a construction that the police were on the porch in Richmond because of consent, Terry doesn't need to do any work at all.
That was Judge Wood's point, and
Yeah.
that's why all of this discussion is dicta.
You know what's odd to me about Terry is if you look at Jardines and you look at Lang's the misdemeanor, the guy in the traffic violation who flees to his garage or drives to his garage. There's not a citation to Terry in Jardines or Lang.
Mm-hmm.
And you would think the Supreme Court, the Supreme Court knows about Terry very well that way. And so Lang is full of reasonable suspicion.
Right.
So, but there's no reference to Terry anywhere.
Right. I mean, the absence of any, I think it was in Soldal where the court mentioned that, if police aren't lawfully there in the first place, no amount of probable cause can justify a search or seizure. And I think underlying the assumptions in Collins and Lang and Jardines, as you mentioned, is this idea that the first question is, are you lawfully there? And that's the question that they're addressing in those cases. The secondary question is, okay, once you're lawfully there, what can you do? And that's the Terry question. That's the Richmond question. So I think probably that the Supreme Court doesn't mention Terry because it says, look, if you don't satisfy this baseline,
Yeah, in
you can't do
Jardines,
anything.
you're not lawfully on the porch with a drug sniffing dog.
Right. It doesn't exactly. It doesn't matter.
Mr. Henderson, how do we deal with Davis here? Okay, Davis versus the United. Here's the reason I'm asking you this. Okay, is the government has a fair point that Richmond says what it says. That way, it has that language in it that we're trying to parse and figure out but it has it in there and it's pretty declarative. about Terry. Why couldn't there have been reliance upon that for the police conduct here that is saved by the reasoning in Davis?
Well,
You know what I'm getting at?
I know exactly what you're getting at. It's an objective standard. We know the police didn't actually rely on this. They testified that they had no idea about these cases. And so the objective test is in a contest between what the Supreme Court has said about entries onto curtilage and what the Seventh Circuit has hinted at in dicta in Richmond. I think the Supreme Court wins. Now, reasonable minds can differ. That's the whole point of the Tenth Circuit cases that the government cites, to say, you know, this issue is, I mean, it's not exactly Jardines. There are some differences. It's a different factual situation. I think the rule of law is the same. But, you know, reasonable officers might read these decisions and say, well, what can we do?
But under Davis, why isn't the proper analysis that a police officer reading Richmond is post-Jardines, reading Richmond would think that, set aside the merits of it, that Terry would authorize entry on the porch given the reasonable suspicion they had from the Instagram picture?
Because Davis requires specific authorization. And so the most you could reach Richmond to say is that with consent, you can enter a porch and perform a Terry stop. That's what Richmond holds. If you went further than that, I would disagree with this reading, but you could say you can approach somebody from the front porch to perform a Terry stop. What Richmond doesn't authorize is sneaking around the back, sneaking onto the side, and surprising somebody. It's sort of the flip side of qualified immunity. If you can imagine the other way, if officers in Richmond said, well, sure, Banks said you can't sneak up from the back, but didn't say anything about a front porch entry, so we're entitled to qualified immunity. It has to be specific authorization. It's not just would a reasonable officer read it this way. Specific authorization is just that. Of course, we believe the government's waived that argument. It didn't make it below, and there's no factual support to suggest the officers knew the law. But putting that aside, this really is a very simple case, as the Supreme Court noted in Collins. Officers should not go on curtilage without a warrant to perform searches and seizures. It's that simple. Thank you very much.
Thank you. Ms. Boyle.
Good morning, Your Honors, Counsel. May it please the Court, my name is Catherine Boyle on behalf of the United States. The District Court here correctly denied Mr. Banks' motion to suppress. The police officer's Terry stop, protective pat-down, and subsequent arrest of Mr. Banks were lawful under this Court's decision in United States v. Richmond, given that the officers in this case, as Banks admits, had clear reasonable suspicion that Banks had committed a crime. But even if they hadn't, as Your Honors noted, suppression wouldn't be warranted here because the officers were reasonably relying on existing precedent, both in Richmond and in prior cases like the Supreme Court's decision in Santana. Just to talk a little bit first about why the Terry stop and associated pat-down were permissible.
So, Ms. Boyle, before you go there, so if in this situation, assume that as the officers approached the porch, Mr. Banks told them, whoa, no, you can't come up here. You know, I invoked my Fourth Amendment rights to curtilage, and you have to stop where you are. Would that take it, in your mind, out of what you perceive to be the holding in Richmond?
Well, Your Honor, as they're approaching the porch, I believe under Richmond, in Richmond, this court specifically stated, it was a very clear statement that reasonable suspicion meant that the officers could be on the porch to conduct a Terry stop.
So hold on for a second. So the government's position is that even if Mr. Banks said, hold it, you can't come onto my porch without a warrant, the government's position is that so long as the officer had reasonable suspicion, they could, despite that objection, still venture onto his porch and do what they did.
Yes, Your Honor. That's correct.
And other than Richmond, is there any other authority that you can cite to support that proposition?
Well, I think when we go back to, I think SOSA, the 10th Circuit opinion, has a really interesting discussion of United States versus
That's a qualified immunity case. That doesn't apply here in this context.
Yes, Your Honor, it is a qualified immunity case. I do think the discussion is relevant, particularly when you look at United States versus Santana itself, in which the police went up to the porch to seize an individual who was suspected of drug trafficking. It's a very similar situation. Santana has not been overruled in the years since, despite an increasing focus on property rights analysis as well. And I believe the court's decision in Richmond reflects that.
Santana is a hot pursuit case?
Santana does involve hot pursuit because the officers ended up following the defendant into the vestibule of her home, but it also involves them going onto the porch to effect a seizure. And that,
right, but hot pursuit is an established exception. You can't fit this case into the hot pursuit exception as a factual matter.
Yes, Your Honor, although I think the hot pursuit in Santana was particularly focused on following her into the vestibule. And we do believe here that they also discuss in Santana how the defendant was on the porch in public view, and that there were potentially...
That's considered his home.
Yes, Your Honor, although...
Considered the boundary of his home. Officers can't invade that. It's not at all like Santana. That suspect was being pursued from a public space into a private space. That's very different from what is at issue here.
Well, I believe the suspect in Santana was standing on the porch at the time officers approached her, Your Honor. But to your point...
There was no pursuit before that?
Well, my understanding is a drug transaction had just occurred. There was an undercover officer in the car with the individual who had conducted the drug transaction. The person returned to the car with the drugs. The undercover officer revealed his identity, and then the officer asked essentially for more details on the transaction and where the money was. The individual said that Mom Santana had it, which was back at the prior residence where the transaction had occurred. The officer went back to the residence and saw Mom Santana on the porch and decided to effect a seizure. And then when she started going into the vestibule, followed her for reasons of hot pursuit.
Well, can we go back to Richmond real quick?
Yes, Your Honor.
Okay. Do you agree that the Richmond opinion, just reading it, reading the majority and reading the dissent, establishes that Antoine Richmond consented to the police being on his porch? Forget Terry for a minute. Just ignore Terry. We'll come to it. Can you read do you read the opinion that way? That yes, both the majority and the dissent seem of the view that on the facts there, Antoine Richmond consented.
Mr. Richmond's position had changed on that point. I believe he initially suggested that he once said there was consent, and then changed his mind on that.
It may have. Just focus on the opinion we issued.
Yes, Your Honor. The opinion contains a clear statement that I don't think the opinion relies on any alleged consent by Mr. Richmond. The opinion contains a specific statement saying that the officer's reasonable suspicion, from an objective standpoint, justified their entry onto the porch. And that to me suggests that his consent was not a linchpin to the opinion, given how clear that statement is.
Okay.
Your Honor, I'd like to also address just briefly the point on the backyard. If we move on from the point as whether the Terry stop is permissible under Richmond, defense counsel has tried to suggest here that the backyard somehow makes this an impermissible interaction, even if it would otherwise be permissible if they had just walked straight up the front walk. And I really do think in this case that approaching through the backyard is a safety measure. It's similar to the idea of a pat down. The officers are approaching a known felon who has a firearm, and the going through the unfenced backyard on an alley is really is really aimed at preserving officer safety in these circumstances. That is something that has been approved by the court in different circumstances, but that have some that can apply in certain ways here as well. For instance, officers can do a protective sweep while they're obtaining a warrant. So there are the courts have previously decided that certain incursions on privacy are permissible where there is a need for the officer's protection as well.
Ms.
And
Boyle,
then
would
finally,
you,
Your Honor,
Ms. Boyle, would you extend that reasoning? Say if the officers had, because they had concern for the protection that entered the house, and went up and were right behind the front door just in case something happened, as a matter of protection, would that rationale also apply?
no, Your Honor, I don't. I think
And so
it's
then,
a little bit different.
and if so, given the Supreme Court's rather, the line of cases that talk about curtilage being basically equivalent to one's dwelling, how would you make the principal distinction between an officer entering into your backyard in order to promote protection versus their entering into the home and going further and just making sure that everyone would be safe?
That's a good question, Your Honor. Yes, certainly the courts have said that curtilage in the home enjoy equal protections under the Fourth Amendment. That said, there have been situations, such as for the knock and talk exception, where curtilage has been treated a little bit differently. And in Richmond, we believe that was another situation where curtilage is being treated a little bit differently. It's showing that the Terry stop is permissible here, and that's for a lot of good reasons. That's because you're looking at
So do you think
person.
do you think that the court should create a new rule that police officers can go onto someone's curtilage if they have concerns about security and safety?
You would need reasonable suspicion to effect a Terry stop to go onto a front porch. In addition to or concurrent with your concerns about safety. You wouldn't be able just to go up because you had an amorphous concern about safety.
What if it was a screen porch and not an open air porch? Would the officers be permitted under Richmond to open the door of the screen porch and enter into the screened in area to effectuate this warrantless arrest?
That would be a different and more concerning situation than we have here. That would also
it's curtilage. It's not the not the interior of the home. It's still the curtilage.
Well, yes, Your Honor, I see your
it's just a little picket fence that has a little gate, but it's still open air. It's a porch with a little picket fence and a gate. Can they open the gate and go in and get him without a warrant?
Your Honor, I believe that this court's opinion in Richmond would permit that sort of Terry stop on a porch, particularly. And one of the reasons for that is when you have somebody, say, with a firearm on a public way, that is more dangerous than somebody who has a firearm in their kitchen. So you have somebody here who is right by a public roadway, has the firearm on the side of the grill closest to the street. And then, of course, this case also has the amplification that he's posting about it on Snapchat to any number of people, including law enforcement, as it turned out. And Your Honors, I see I'm running out of time. I would just like to, if possible, briefly make the point that regardless of the decision on the permissibility of Terry stops on curtilage, this is a case where Davis should absolutely apply. The officers here could clearly rely on the very direct statement in Richmond and additional case law that we've discussed today to say that, to believe that this conduct was permissible. There is no reason to, there's no objective to deter police misconduct here, given that the officers were not trying to engage in misconduct. They were trying to follow the law. They were trying to do the right thing. They were trying to do good investigative work, and they were trying to conduct a Terry stop of a felon with a firearm who was broadcasting it on the internet.
Thank you. Thank you very much.
Thank you, Your Honor.
Mr. Henderson.
A lot of the government's argument relies on these sorts of balancing concerns, which we used to do under the Fourth Amendment before United States versus Jones said, look, those balancing privacy, expectations of privacy, what's exposed to the public view, all of that is secondary to whether this search occurred on a protected area and whether officers were entitled to enter that protected area. And the Supreme Court keeps telling us you need a warrant or you need an exception to the warrant. The only relevant exception here is the knock and talk exception, and the Supreme Court has delineated what that means. It doesn't mean sneaking through the backyard. It means literally under Jardines, approaching from the front path, seeking a consensual encounter, knocking on the door, seeing the homeowner will talk to them, and if they refuse, you leave. The French versus Merrill case, I think that we cited, the officers did just that, except they kept pounding, and the court said, you don't get qualified immunity, you have to leave. So this case really is very straightforward. Richmond.
Well, you know, in fairness, the curtilage cases do kind of come out all over the map and point in different directions about the strength of the protection in curtilage and whether there's room for reasonableness balancing. And maybe that's all implicitly overruled by Jardines.
I think it has to be. I mean, it's what happened in Collins versus Virginia, where we said, well, we've got the automobile exception. The court said, yeah, you're on curtilage, though. You need something separate. There's a separate interest. So unless police officers are lawfully on the curtilage, as they were in Richmond, they are not permitted to search and seize somebody who's protected by the Fourth Amendment in his home. Thank you.
All right. Thank you very much. Our thanks to both counsel. The case is taken under advisement. And we'll move to our next.
Thank you.
Thank you. We'll move to our next case this morning, United States versus Miller. Mr. Gillen.
Thank you, Chief Judge Sykes, and may it please the court. My name is Sam Gillen, and I represent the appellant, Robert Miller, in this matter. This court should reverse the district court's denial of Miller's motion to suppress the firearm in this case, and it should do so for three basic reasons. First, by seizing and pressing Miller's keys without a warrant, officers conducted a Fourth Amendment search under Correa and Concepcion. Second, that Fourth Amendment search was unreasonable because it does not fall within a specifically established and well-delineated exception to the Fourth Amendment warrant requirement. Third, evidence of the gun should have been suppressed because it was fruit of the unlawful search. And if it's all right with your honors, I'd like to focus in on the second point because it seems to be where the parties differ the most. And so in determining whether a Fourth Amendment search was unreasonable, it's important to bear in mind the longstanding Supreme Court precedent that warrantless searches are per se unreasonable, and that's only subject to a few key phrase here is specifically established and well-delineated exceptions. Here, the United States offers three potential exceptions to the warrant requirement, and none apply. And I think the most troubling is the first one, which is the United States reads the key Seventh Circuit precedent, Concepcion and Correa, as permitting warrantless searches whenever the privacy interests of the person being searched are sufficiently small in view of law enforcement interests. And so I think the issue here is the United States cites to Correa for that proposition, which in turn cited to Concepcion. And Concepcion said, this is a close paraphrase, but something to the effect of, how much cause is required for a given search depends on how deeply they invade the zone of privacy. And for that proposition, Concepcion baldly cited an earlier case, U.S. v. Chaidez. And that case was actually a seizures case. And so there's kind of two issues there. The first of which is that without explanation, it's broadening this proposition for seizures cases to all Fourth Amendment cases. But more fundamentally, it violates the longstanding Supreme Court rule that warrantless searches, in order to be reasonable, must fall within a certain exception to the Fourth Amendment. And so that's why Concepcion and Correa, which both involved using keys of an arrestee, must be read as invoking the search incident to arrest exception in order to comply with the per se rule. And the interest balancing exception of the sort contemplated by the United States contravenes the very idea of being well delineated. It's a rule that will require an ad hoc judicial determination after the fact regarding whether the privacy interests involved are sufficiently weighty. In the normal course, that is a determination being made by a neutral magistrate before the fact and not by officers. It also contravenes the policy behind the per se rule as stated in United States versus Katz. Again, it bypasses the neutral determination by a judge and leaves individuals' rights secure only in the hands of officers who have every incentive to find circumstances warranting a warrantless search. Moving on to the next exception, the United States also invokes the automobile exception to the warrant requirement. Here, that quite plainly doesn't apply because the search was of Miller's keys, not his car. I'd point out, firstly, that Correa characterized the search there, which was the case where DEA officers were clicking a garage door opener. It characterized the search there as, quote, an interrogation of the garage door opener's code. Not a search of the garage, a search of the key item. And I'd also point out, Your Honors, that keys don't necessarily have to be for a car. They could be to a storage unit, a diary, all sorts of things, each of which have their own attendant privacy interests involved. And so I think it's important to leave that determination and weighing of interest to the neutral magistrate before the fact, rather than leaving it to officers who, again, have every incentive to find circumstances warranting a warrantless search. I'd also point out that characterizing this as a search under the automobile exception doesn't comply with the policy behind that either. Generally, with cars, there's a lesser expectation of privacy because they're pervasively regulated. You have to have a registration, a license, etc. The same isn't true for keys. Also, cars are readily mobile. Cars, by their nature, are meant to move places. Keys might be readily mobile in the sense that you can put them in your pocket and walk away, but they're no more readily mobile than, say, a wallet, a cell phone, things that would unequivocally not be considered readily mobile. Finally, I'd address the United States exigent circumstances argument. They offer this even though it was not...
That's your third, right? Exigent circumstances?
Yes, Your Honor.
You got to get some point here, your time's clicking on you, got to get to independent source.
Okay, Your Honor.
Right, that's the basis of the decision. The district court relied upon the independent source doctrine.
The district...
Judge Shadid, did he not?
I think he relied on that in the alternative, Your Honor.
Right, so let's talk about that.
Okay.
I just want to make sure we get the benefit of your perspective on that.
Understood, Your Honor. So I point out there that there's an unbroken causal chain here between when the officers found out that the car was Miller's, they then circled back and investigated later and saw a gun, and based on these two key facts, they decided to seek a warrant. And I note that the warrant here was not to investigate my client who had been shot in the face. It cited the Illinois felon in possession statute. And so in order to have probable cause for felon in possession, you need to know that there's a firearm, and you need to know that there's a felon who possessed the firearm. Officers would not have known that the gun and therefore the car and therefore the gun was Miller's without having done the unlawful search and clicked his keys.
What about the DMV, the record search?
Your Honors, they could have.
Well, we know in fact they did it.
They did after they had already confirmed that the car was his by virtue of clicking it. So it's kind of just covering their bases, so to speak. We don't necessarily know that they would have gone through that procedure had they not known whose car it was. To the extent that we want to say that, oh, well, officers definitely would have in the normal course, well, they had every opportunity at the trial court level to present testimony saying, okay, well, if we had not clicked the clicker, this is what we would have done. We would have run the...
Don't you think it would have been a gap in their search warrant application? Don't you think the judge issuing the search warrant would have said, I just got a very basic question. Whose car is it? Who's it registered to?
Well, I don't think there's...
That's probably why they included it, because it's one of the first steps that's done.
I think the fundamental, I'd return to the warrant being for the unlawful possession statute. They wouldn't have had a motivation to run the DMV thing and search.
Sure they would. There was blood in the car and it was shot up. They had every reason to search the car once it was impounded. Whether or not it was going to form the basis of a felon in possession charge against your client or evidence of other crimes. They were following the leads that were forensically in the car itself.
Your Honor, I think we're kind of substituting what we think would have hypothetically happened for what should have been in the first instance testimony by the officers saying this is what we would have done. So I don't think we can take it as a guarantee that they would have, absent the knowledge that the car and the gun was Miller's, ended up searching the car for evidence related to the initial crime.
But before they pushed the key fob, they saw what Chief Judge Syke, they knew they had a guy that was shot and hurt pretty badly, right? Shot in the face.
Yes, Your Honor.
Okay. They saw the bullet holes on the side of the Crown Victoria.
Correct.
They put the flashlight in there and they saw the blood in the car.
Yes, sir.
Okay. It's inconceivable to me that they would what? Have him taken away in an ambulance and then they would just leave the scene?
Again, Your Honor, I'd just say that we don't necessarily know what the officers would have done. Admittedly, maybe a little unlikely that they would have just left the car. But again, that was...
It would have been unheard of. They were going to impound that car.
Well, that's
it's
why
evidence of a crime.
The other thing you have here, in keeping with that comment, is I think you've got an inventory search issue in the back of this. That's not in any of these opinions, but they're not inconceivable, maybe an understatement. They're not going to go about their patrol work and leave the Crown Victoria sitting in the middle of a street in these circumstances and just abandon it. There's no way. So that car is going to the station house almost no matter what. I mean, either the station house or the auto pound, one of the two. Right? I mean,
it's fairly likely, but I'd just return again to the same point that we don't necessarily know that that's the case. And I see that I'm running low on time, Your Honor. So for these reasons, the court should reverse. Thank you.
Thank you. Mr. Keenstra.
May it please the court. Good morning, Your Honors. Jeff Kinstra for the United States. The district court correctly denied the motion to suppress, and there are 4 independent grounds on which this court could affirm. I'm happy to answer your questions on any of them, but I'll start where we left off, which is that the independent source doctrine is really an inescapable ground for affirmance here. The district court did expressly rely on it. The 2 questions there are, did the challenged activity affect the judge's decision to issue the warrant, and did it affect the officer's decision to seek the warrant? On the first question, probable cause here existed before the officers even pressed the key fob. As Your Honors have observed, even before then, they had observed, of course, they were called to the scene of a shooting. This is a very dangerous incident. There are 5 bullet holes in the side of this car. They look inside, and there's blood all over the passenger seat. And next to it, of course, there's the defendant who is bleeding from gunshot wounds. So his connection to the car and the car's connection to the shooting, even more importantly, is really inescapable. The officers knew that already, even before using the key fob, and those facts are all set forth in the warrant affidavit. So the warrant sets forth probable cause to search for the shooting. As opposing counsel notes, the warrant did say that it was investigating a felon possession offense, but that's really not dispositive. The warrant only has to provide probable cause. Here it was supported by probable cause. And even if the officer cited a different or even the wrong statute, that wouldn't undermine the warrant itself. And so the next question then is, did this affect the officer's decision to seek the warrant? For many of the same reasons, it's not only unfathomable that the officers would not have sought the warrant, but the district court found as a matter of fact that the key fob is not why they sought the warrant. What the court said at the top of page 3 of its ruling is that they sought the warrant, or that what led to discovery of the evidence was their observations of the bullet holes and blood in the car, and the victim next to the car suffering from gunshot wounds. The defendants suggest that there is some sort of evidentiary gap because there wasn't testimony at a hearing about what the officers would have done, but there was a stipulation which put forth all the facts before the district court, and there were also body cam videos. And I think those videos are really revealing because it shows that multiple officers at different times during this investigation observed these same facts and audibly remark the same observation, something like, oh, he was in the passenger seat, or he was in the car, or the key is probably his, as Officer Mark said before he actually picked up the key and pressed the button. So to the extent that the officers sought the warrant because the defendant had some connection to this car,
the officers already plainly knew that the defendant was likely connected to this car. Beyond the facts I've noted already, it was the only car nearby, and he has a key in his hand, which suggests that he was about to or had just accessed a car. So the facts really plainly show that the officers were going to search this car. They had the probable cause to do it. And so even if there were questions about the key fob itself, the independent source doctrine would fully support the denial of the motion to suppress. And the defendant can't show that the district court committed clear error in finding that the officers would have sought the warrant anyway. As to whether any violation occurred, I'll begin with the key fob itself. And this court's precedent already establishes that the use of a key for the sole purpose of learning what the key corresponds to does not constitute an unreasonable search so long as it doesn't reveal any further information about the interior or contents of whatever the key corresponds to. And the reason, as this court has repeatedly recognized in Concepcion, and then again in Thompson, and then again in Correa, is the limited privacy interests. And there are really two dimensions to that. The first is that a key is only capable of conveying a very limited piece of information. It can't say anything about the interior contents. It can only say what does it unlock. And second, that's a piece of information that a person has a very limited privacy interest in the first place. Now, Concepcion and Correa involved apartments and garages, and even then the court said that because that information is readily discoverable, that a person has very little information in merely the identity of their apartment or garage or apartment building. Now that applies with even greater force here because just like in those cases, the key fob can only identify the car to which it corresponds. And a person has much less interest in privacy in the identity of the car that they own than in their garage or their apartment. Cars as a class, of course, are pervasively regulated. The state they have to be registered with the state. The state maintains these records. Cars have to bear license plates, which make it very easily accessible for officers to determine who owns them. And so the privacy interest here is much less than in this court's prior cases, and the key is no more revealing than in those cases. So this court's precedent really controls. The defendant tries to distinguish them as applying only the exception for searches incident to arrest, but that's just plainly not what those cases say. Concepcion said that the privacy interest is so small that officers don't need probable cause. In Thompson, the court again said that the privacy interest is so small that officers don't need probable cause or warrant to conduct that activity. In Correa, the court said that pressing the button was reasonable because the searches revealed only an address and the defendant had no reasonable expectation of privacy. So this court simply was not applying the exception for searches incident to arrest. I note that the defendant suggests that the rule this court has established invites all sorts of different line drawing problems, and that's really not the case because this court's rule is already very clear, it's very well delineated, and it's long-standing as well. Again, it only applies to the use of a key and only then for the limited purpose of determining what the key corresponds to. So this isn't a wide-ranging inquiry, it's a very narrow factual situation. And that's been the court's law for 30 plus years now, and the defendant hasn't shown the sorts of difficulties that he posits that rule would create. The other limiting factor of the rule is that it can only apply when officers have lawful access to both the key and whatever it corresponds to. So the rule against unlawful seizures almost has more work to do here, but the defendant hasn't claimed in this case that there's an unlawful seizure, so that's waived, and there wasn't, because this was a key that the officers had removed from the defendant's hand while searching him for bullet holes, essentially. It was lying on the grass, and they picked it up. As to the automobile exception, really the key there is that, first of all, there was probable cause, and then second, a person has no greater expectation of privacy in the key than the car itself, and the defendant suggests that keys aren't inherently mobile, and that's a little bit suspect, but cars certainly are, and a key only conveys information if it's used in combination with the car. So the car's inherent mobility would defeat the officer's ability to determine what the key corresponds to, just the same as it would impair the officer's ability to search the contents of the car. And so the reasons for the automobile exception apply fully here, And the Eighth Circuit has expressly held that in Cowan. The defendant acknowledges that on page 3 of his reply brief. So a contrary holding by this court would require creating a new circuit split. Not only is that unjustified, but it would be incorrect. So the automobile exception applies and supplies an alternate additional basis for the affirmance. And last, with exigent circumstances, I just note this is obviously a life-threatening emergency. Someone who had been in the car had been shot. There were 10 bullets fired, only 5 of which were in the car. So that could have left multiple different victims. Officers had an interest in learning if it was the defendant who had previously been in that car or if it was someone else. Because if it was someone else, there was someone who's likely in distress, having suffered a gunshot wound. And the very modest step of using the key fob to determine if perhaps that was the defendant's car, if it was the defendant who had been in that passenger seat that was filled with blood, served that purpose. So for all those reasons, the government believes that the district court correctly denied the motion to suppress. And unless your honors have any questions, we'd ask this court to affirm.
All right, thank you very much.
Thank you.
Mr. Gillen, a rebuttal. You had used all your time, but if you've got something to say in conclusion, you can have an extra minute. Anything else to say?
Not in conclusion, I just wanted to address.
Sure.
I just wanted to take a second, since opposing counsel addressed exigent circumstances, to give our side on that as well. The problem here is there's no objectively reasonable basis for the officers to believe that there was an ongoing emergency sufficient to justify using Miller's keys. There were several officers on the scene. They had already cleared the scene with flashlights. There was no apparent trail of blood, a door ajar, or anything like that to indicate that there was somebody else here. And so for that reason, I would again say that exception does not apply. Thank you, Your Honor.
All right, thank you very much. Our thanks to both counsel. The case is taken under advisement. And our last case for argument this morning is Carol Eskowiak versus Kijakazi. Mr. Forbes.
Back again, Your Honor. I'd like to start out with a couple of things of clarification. In the record, at one point, there was something that the term light duty was used. Light duty is not a Social Security term, it's a work comp term, and it just means a lesser duty or a modified duty from what was before. In the Social Security world, by regulation, light duty involves 10-pound lifting frequently, 20-pound lifting occasionally, sit and walk up to 6 hours out of an 8-hour day, and sitting 2 hours out of an 8-hour day. And one way to conceptualize light work is if you were to walk a ultra leisurely pace of 1 mile an hour, you'd cover 6 miles a day maximum in light work. If you were to walk a slow 2 miles an hour, that's 12 miles a day. 5 days a week, 12 miles a day. That's how much walking is involved in light work.
I thought the scope of this appeal was limited to whether the ALJ appropriately analyzed the evidence of her back condition after the date of last insured, and that was especially conceded in the reply brief.
It is, and I'm just giving context because the RFC that the ALJ ended up at was light. But I only had one more thing to say, and then I'll just move on, if that's okay, Your Honor. 10 pounds, and during those walks, you're carrying a 10-pound bowling ball 2/3 of the time and a 20-pound something the rest of the time. That's what light work is. That's what this judge alternatively imagined that my client could do.
Mr. Forbes, focusing on the record here, can I ask you a question?
Sure.
On November 23rd of 2018, your client is diagnosed with what's referred to as laminectomy syndrome.
Yes.
Okay, and you make the argument, because I think it's in the same location of her spine, okay? You make the point that this is what connects us back to the 2011 back surgery and the back problems that she was having around that time, and that they basically continued, and then they flared up, in a meaningful way in 18. That's the argument you make.
That's correct.
Where is the medical evidence backing the argument? In other words, where would you point me in the record to understand as a medical matter, as opposed to an argument made by counsel in an appellate brief, that as a medical matter, the diagnosis of post-laminectomy syndrome?
August 16th, 2016, at Administrative Record 575, I believe, is when the family doctor assesses chronic midline low back pain without sciatica, and then there's an orthopedic referral. I believe there's actually two references to that. For some reason, I only wrote down.
I have the record right in front of me.
Okay.
From Parkview.
Yes.
Okay, I got it.
Here's why midline back.
How do you connect it, though? I don't.
Midline back pain is where the instrumentation is. The testimony is that the sciatica flares when she overdoes it. So the sciatica is kind of a waxing and wane, which this court has acknowledged happens. The old case in the mid-teens, I didn't cite it, but it's Thomas.
Can I ask the question a different
Sure.
way? Okay, in these proceedings,
Yeah.
is there anything that would prohibit the applicant, so here Carol L., from submitting evidence that explains the medical terminology and as an evidentiary matter allows points to be connected? Because when you say chronic midline low back pain without sciatica, well, I'm
And
not trained to
orthopedics.
know what it means. I don't know. I could Google it. I
Yeah.
could go look in a medical. I don't know what it means, though.
From a litigation standpoint in an administrative.
Don't you have an ability to present evidence to connect all this?
Evidence can be presented, but this is not a personal injury trial. The claimants can't afford thousands of dollars on medical experts. About all we have is to refer you to the basic medical text like Merck Manual Professional, or as in, say, the last argument we had where there was a doctor that went above and beyond to write extra notes. If I had an unlimited budget on each case, I could connect all dots, but
but what concerns me is
Yeah.
that I don't know, under the standard of review that we're operating, that I don't know what evidence we point to say that the post-laminectomy syndrome at L4, L5 prove the connection to the prior period.
it does in the sense that the doctors post DLI reference it. The question is, what functional limitations did she have during the trajectory of that period? And that's why you'll see that the testimony focused primarily on 2017, which is the year before the DLI, and so basically we have the connection post the second surgery to the first surgery. We have the thing that happened in 2016. We have some anti-inflammatories that were used.
I don't know.
And we
I
have
don't
her
know that the
testimony.
2016 connects
Yeah.
it to the prior period. That's your argument. What I'm trying to focus on is where is the evidence that connects it, other than your say-so at the podium.
Well, the evidence is the identification of chronic midline pain.
Well, I don't know what that means.
Um,
How do I know? How are we supposed to know what that means without evidence?
But didn't they say chronic midline low back pain? Is the word low in there?
It is in there, but that
Okay.
could mean that
that's
she's
the lumbar
coming.
spine. I understand your frustration. I practically have had to learn how to become a doctor in the last 30 years of doing this. That's pretty much, what we got there. And then, but I do understand. I mean, I wish there were more here too, Your Honor. I'm not going to. I do not mean to minimize your concern. Let me pause a second. Why don't I reserve the rest of my time? And,
That's fine.
Thank you.
Thank you. Ms. Hahn.
Good afternoon. May it please the court, Lou Hahn on behalf of the Commissioner of Social Security. I'll begin by paraphrasing Mr. Forbes' statement that evidence could have been presented. It certainly could have, and to answer Judge Scudder's questions, it wasn't. At the hearing, which is a non-adversarial hearing, not a personal injury trial, ALJs often, and the ALJ in this case did, ask Ms. Leskowiak and her attorney if the record was complete. A claimant's attorney can ask to submit evidence after a hearing. Here, Ms. Leskowiak, as often is the case, also requested review by the Appeals Council of the Social Security Administration, and at that time had the opportunity to attach any other medical evidence to that request for review, and she didn't.
So in your experience, there's an opportunity that an applicant has to work their way through the medical records and to say the diagnosis in November of 18 of the post-laminectomy syndrome is absolutely connected back to the surgery that was done in 11. They have that opportunity to present that evidence, and then you can make whatever argument you want to make about it. The only point I'm trying to make is that in the administrative proceeding, that ability is there for an applicant.
Yes, Your Honor. And here what we have is an absence of evidence. Between the period of time when Ms. Leskowiak alleged she became disabled, January 10, 2013, through the end of the insured period, the end of 2017, December 31, 2017, there is an absence of information, medical evidence with regard to the severity of her back impairment. And that's what you find in the ALJ's discussion. ALJ Pearson talks about this at step 2. Step 2 of the 5-step sequential evaluation process is where an ALJ determines if a claimant has severe impairments. And that's a term of art under the agency's regulations. An impairment must impact work abilities. The ALJ scoured the record here and pointed to the absence of any significant findings. There were significant findings, as Your Honor saw, in 2018, coming 10 to 11 months after the expiration of Ms. Leskowiak's insured status. For example, in November 2018, she had a surgery. But Your Honor's point is key. Here, there is no connection between that November 2018 surgery, after which she also reported improvement. That is around page 1041 of the transcript. That's, again, outside of the period at issue. But during this 5-year period of issue, there's really no showing of any severe impairment, let alone the back impairment, which is what Ms. Leskowiak is focusing on here in her appeal. Her appeal to this court focuses entirely on the severity of her back impairment. And in that respect, the ALJ was reasonable. Sitting here making arguments, positing on what could have been in the evidence, is something we could all do. Those of us who are not doctors, we could think about what could have been. But what was there and what the ALJ discussed and considered was reasonable. There's simply no grounds for this court to send this case back to the agency for further consideration. The decision here was complete. It explained the grounds for the ALJ's decision at step 2, alternative findings throughout the next steps of the sequential evaluation process. And here we ask that this court affirm the ALJ's decision, unless your honors have any specific questions about the ALJ's decisions or the evidence. We rest on our brief. Thank you.
Thank you. Mr. Forbes, you had little time left.
I think the record is, it's indisputed that the connection's made, that the orthopedic surgeons in the 2018 surgery and a few others make the connection. The evidence is firm that post-laminectomy syndrome connects. But
You know what question I'm going to ask you?
yep, and I'm probably going to talk about
What
it right now.
evidence? What evidence?
Whatever. Well, it's cited in my brief, in my argument. I'm positive. I don't have it in front of me right now. But so the next question, though, is to what extent is her pain limiting during that period? And then the next question is her testimony about that pain consistent with this idea of post-laminectomy syndrome? What I'm arguing is that as of 2016, when her family doctor refers her to an orthopedic surgeon. Why did the family doctor do that? And all I can argue is from inference, is that it was chronic midline low back pain. That's where the instrumentation is. That's why she needs to send her to the surgeon as opposed to another specialist. I mean, she could have sent him to a pain specialist. She sent the claimant to a surgeon. So the next question is, how do you connect it from 2016, 2017 to 2018? And she was taking pain meds and she testified.
All right, Mr.
Yeah.
Forbes, your time has expired. You'll have to wrap up.
Since I'm last, may I answer the question about whether there's more evidence available?
That's what I thought you had just done, but
No, I meant in general in these administrative proceedings.
if you would please wrap up and answer the question directly.
Yes. Administrative law judges are under duty to produce a full and fair record, and they can ask for more. Sometimes there is no more as far as medical record. That's what complete means. So, thank you.
Thank you very much. Our thanks to both counsel. We'll take the case under advisement, and that concludes today's calendar. The court is in recess.